Good morning. So the cameraman already got busted this morning. The cameraman was showing Karen and her father talking, and the bailiff came over and made him raise it up till court starts. You got to be up. You got to be up. Sounds like Elise has audio issues. So we'll just hold on until she gets that fixed. Welcome in, everybody. Good morning. Good to see you. Well, welcome in, Casey. Good morning, Bree. Good morning, Anastasia. Juju Drops. Captain Ganja. Freak Aaron Reed. Oh. Crap. Okay. Let's see what I can.
Versus Karen Reed. Can the counsel identify themselves? Starting with the Commonwealth.
Good morning, Your Honor. Laura McLaughlin.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Adam Miley, the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti. All right, so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCA. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So.
Well, this is totally interesting. Maybe she's gonna ask her if she can afford another counsel. This is history making right here.
Can y'all hear me?
Yes.
Okay, I'm using my phone right minute because I'm trying to figure out the audio still because the update on my computer yesterday completely put it in like a different folder and I can't find it like I found it yesterday. So I'm still looking, but I want to be able to comment on this. And holy shit, I didn't think she was going to do this until maybe after the trial. She's going to decide sanctions, but I really want to hear this sidebar. And I don't understand why she is saying she's going to seal the sidebar.
Probably because what she's going to talk about with Karen will affect whether it's like the outcome of the trial.
Yeah. Well, I mean, it's going to one way or another, and we have the right to know it as a public interest in it. But I wonder if, I mean, she said before she decides sanctions. You guys might hear like double. No, you won't actually, because I have my headphones in, but I'm still trying to figure out the audio on my computer so that I can do it there. Yeah, it is simple. They did lie.
So the pipes burst at my apartment.
Like we're missing I did not think she was going to do this. I figured if she was going to do it, it would have been before she did some of the other stuff. Oh, thank you, Ange, for sharing the link.
Yeah, normally I do a morning live about this time, so I didn't do my morning live. So you may see a lot of my flockers in here today.
Hey, that's okay. They're more than welcome. Uh-oh, here we go.
Oh, they do not look happy, do they?
All right.
Well, they're on hold.
So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because
has to
Mr.
be.
Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep
That's nice.
all of her lawyers, notwithstanding the Rule 14 violation and the apparent
care if she
lack of
wants to keep
candor,
them
the
or not.
findings and rulings I've made. So based on that, I am not going to revoke Pro Hoc Vice
Come on.
licenses. I don't expect to have to address this again. Candor with the court is essential. It's the
Are you
bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So Commonwealth, I am denying your motion to exclude the ARCA witnesses.
What?
Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So,
Well, they're
That's
definitely
my
limited
ruling on
in
that.
saying they're not fucking independent.
so we'll move on to Mr. Lessie. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
So that's it. That's all the trouble they get.
Yeah, pretty much. And I'm like, dude, they're going to keep doing it. She damn well knows that.
May it please the court.
Well, the bar will definitely have a
The
complaint.
proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, is cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, 1 paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his finding, he says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a podologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they...
Building your online business? Go to Wix.com and set up your store on a single integrated platform. Add products, showcase them dynamically, and seamlessly track your inventory.
I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is fractures of the classification and clinical features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta study. They went back and looked at a lot of data and information, but it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his 1-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury. And that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy, and we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner. He's not a forensic pathologist. He has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article And I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin. And in the alternative, we would request an evidentiary hearing because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts where there is no statement of the methodology, as here, there's none. And there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the two prongs of the Daubert inquiry?
All right, thank you. Mr. Brennan?
May I?
Please.
Attorney Lessie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD in severe head injury, improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. Book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries, intracranial pressure, number 2 on his journal articles, initial management of brain and spinal cord injuries, number 9, number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16, fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles, presentations specifically on fractures, basal type injuries. Number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon who has this extraordinary experience is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar.
What if the lottery was on your phone? With real tickets, real winners.
Diagnosing what the injury is and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. La Posada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. La Posada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with counter-coup, having treated tens of thousands of patients, and he understands in counter-coup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of counter-coup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth. But we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Leslie, anything final?
Yes, thank you, Ron. Mr. President. Thank you. Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors.
Can you guys hear
And
me
that
now?
is the fatal
Yes.
aspect of
Maybe.
Dr. Wolf's opinion.
Yes, I
It's
can
not
hear you.
stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate
And
for purposes of this argument only the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit
I know, right?
his testimony to cause of death, not manner of death. Because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV, there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did, because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Dalbert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Do you want to respond at all, Mr. Brennan?
Yep. He's still messing up manner and cause. Like, Alessi, come on, man, go back to environmental law, bub.
At some point, arguments become semantical.
Yep.
And theoretical, but not practical. This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon, engaging in the operations in the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious. Thank you.
Okay. Thank you. All right, so we have a series of motions in limine.
A series is right.
Start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on this motion.
Thank you, Your Honor, if I may.
You may not.
This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like
we attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced in the evidence.
Did she adopt it? Was there? Okay.
She did indicate, and that's part of my argument, Your Honor, which
So I'll go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall.
So let me just have, so you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit.
Yeah, no.
That's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's a very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
Would be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
I mean, so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this. This deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass. There were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time, right?
This is more attendant to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were originally from.
So your credit tanked, and now you have 3 roommates.
Sorry, guys.
You're in luck because Self will securely report your positive rent payments to all 3 credit bureaus for free. So you could increase your credit score and improve your living situation. Get free rent reporting. Download Self today.
7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
do you have the day of her testimony?
Gosh.
Ms. Little, do you have that transcript pulled up?
A lot of them refer to their reports, including your own witness, for sure.
So obviously, I remember her testifying. I remember seeing this previously.
June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her. on the witness stand, and she did adopt it, and she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence, what matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right. What's the objection, Mr. Brennan?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there, but also it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face.
Yep.
Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
All right, so Mr. Jackson, what I'm going to do is just hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. I need to hear more of the evidence again.
I understand.
And I'm going to read the transcript, so that will help me with
I think
this.
it makes sense.
Yeah,
Mr.
basically
Brennan
because he
indicates
doesn't tell
that
the truth.
chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think
Doesn't matter. He has to know.
Sure.
Ms. Hanley testifies, then that would be the appropriate sign.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to
Yeah,
working
right.
with them if there's something they
Can't talk to them
All right,
because they don't
great,
tell
thank
the
you.
truth.
All right,
That's
so no action
half
taken on
the
paper
problem.
558. So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to a state of mind. So the Commonwealth's Bins and Qualls motion, does that address the Aruba witnesses? I'm just wondering if they're hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though. So the defendant's motion to eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals
I agree.
with
Doesn't make
the,
sense.
let's just say the Aruba
We'll be here, Anna.
witnesses. I don't, Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is
Okay.
limited, this argument will be limited to the, we'll call it the Aruba incident.
Okay.
The Aruba
All right.
incident.
So given that, that might not include the
Incident,
Commonwealth's number 11, the quals, bans the defendant's statement, the victim's state of mind.
Yeah.
As it goes to the defendant's
Sorry.
knowledge and ability, likelihood to act on that state of mind.
I wasn't even looking at the screen. I was in the living room.
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
so I just want to know if that is part of the Aruba one.
Okay.
So our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event. I reserve the right, if the defense opens the door, then we may proceed with it. But in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
Shortest
There we go.
argument ever.
All right. All right. So Mr. Brennan, you can have a seat again and we'll go through the defendant's one. That's very helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief.
They reserve the right, though, in case they need to show how nutty Karen is. I think it's just extra,
If
the
that
Aruba thing.
changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank
All
you.
right. All right, so that was 5:59.
You take me.
The defendant's motion to eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for a view, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I am, Your Honor.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view,
Okay.
okay, but let's talk about your client attending it.
Yes, Your Honor, there was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
How do you propose that's done?
Yeah, that's not going to happen.
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus, if the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions.
Smart,
And,
Brennan.
It can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place. If that's what we decide, we may have to do it all at once.
I do
So-
think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes.
No.
So that the jury can get a sense of what it would have looked like at the scene.
But that's
And I
not what it
think
would have
just
looked
for
like.
convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right. So let's try and figure out some of the particulars.
Ah, fuck.
Hey, sweetie.
Bev needs to
Honey, everything
say
okay?
no.
What happened, hon?
Hank's right. It shows an incorrect picture of it because it's not nighttime. It's not snowing.
All right,
It's
so
not
defendant's
like,
motion eliminate to exclude certain witnesses before and
Not dark.
after testimony. That's 462.
yeah, the
And
cop.
I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry. 562 and 576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses
Aiden,
before,
right?
after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean
No.
after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so
Not
witnesses
happening.
are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes,
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony.
They have a right.
During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in
So?
the jury box with the O'Keefe family.
So
At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence
please.
at closing arguments.
One that
Um,
wasn't allowed to actually go in the
Your
jury
Honor,
box.
a sitting
Too
juror
bad.
reporting feeling intimidated by the presence of third-party
Please.
culprits towards the close of the case is highly concerning.
No,
Was
it's
this
not.
a deliberating juror?
I
No,
don't know. She was
No.
He or she was anonymous.
Okay.
it was not a deliberating jury. You know that. No, the answer is no.
And Your Honor, that
She was dismissed.
was by design.
For being
There is
pre-Karen Reed.
information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments.
Yeah, that's
And
definitely
so,
what they
On
wanted.
that basis, the defense is requesting, in order to protect there from being any sort of
Nope.
undue influence or
Not happening.
intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case. We're asking that they be sequestered
Nope.
After their testimony
No.
and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right. So obviously
No.
is not something it should be in a motion.
No.
Okay. If you've got an agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted.
No.
Okay.
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
Exactly
All right,
why a
so you
third
all
party
need
should be
to talk.
disallowed.
All right. And if there's a disagreement, you need to put it in writing.
Mr. Brennan has a right
Generally,
to speak.
experts are permitted, but it's not a given. Okay. All right, Mr. Brennan, do you want to weigh in on people being able to? I'm concerned about after the evidence is closed.
Here we go.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name
That's right.
Higgins, Albert. They invoke those names. They characterize third-party culprit. And they suggest that some anonymous person was uncomfortable.
Oh, well.
It seems as though the presentation has a deliberate point.
Yep.
Promote a cause, but doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed.
Yep.
The sequestration order has ended and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government. And certainly I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family.
Yep.
The idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law,
nope,
in justness, in courtesy. And
nope.
so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit of proceedings, even if they may or even if they do become witnesses.
Okay.
Your Honor, if I could address one issue.
Sure.
There is some
No.
additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
Oh, sidebar, really? All right, well, since it's a sidebar, we're going to play my friend's favorite clip ever, 4 sidebars. And if you get a chance, please like and subscribe if you want, or you can make a donation to the channel. The information is scrolling at the bottom of the screen on a ticker. You can do Cash App, PayPal, Venmo. We only survive from donations from our viewers. We're a very tiny channel, so we very much appreciate it. Now, she said sidebar, so we play this when she says sidebar.
I think we got a super chat. I think we got a super chat.
Free Karen Reed, everyone. Free Karen Reed.
Well, that was some bullshit this morning. I seriously thought that she was going to
do something, anything.
That was some absolute bullshit.
She thinks for 1 second that they're magically going to stop misrepresenting and lying in the courtroom. She's got another thing coming. So that's what doesn't make sense to me, is like, you found that it was deliberate, you found that it was on purpose, and that it's happened numerous times, yet you don't do shit. What's the sanction?
The only thing that I've seen is that she's got it on the record so that, you know.
But that's not even a sanction. Yeah.
Right. It's just on the record, in my opinion.
Right. Like, oh, well, I'm not going to tolerate. Yeah, here's the thing. You are, because you have this entire time. And that's my critique of the judge is like, lady, you have been allowing them to do it for this long without doing anything. So you'll let Alessi immediately get up and then lie to you and misrepresent something literally again after she just said, I am not going to deal with, you know what I'm saying? So it's like so frustrating to me because it's like, lady, you need to take control of your courtroom. I don't give a shit what Karen Reed wants. No one gives a shit what Karen Reed wants. She and her attorneys gave up that right to have the Pro Hoc Vice not taken when they decided to continuously lie and misrepresent in the court. Like, come on, you have no candor to the court. Something has to give. If the Commonwealth did that, let me be clear, nothing wouldn't happen. Something would happen. Probably a mistrial, just saying.
But I'll take a closer look at both of these and have something later.
Notice they did not argue for the sewer turtle to be able
All
to
right,
be allowed.
so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
No.
That's also mine, Your Honor.
Okay.
I believe the Commonwealth has indicated that they will agree to that.
Okay.
You believe or you know? See, that's the difference. You
All
know
right,
or
so
you
paper
believe.
565.
In a wrinkly
allowed
suit.
by agreement.
Unreal.
So 566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor. Thank
Okay,
you.
so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire?
Kathy, look, he's on the end of the
request
is right there.
Pretty straightforward.
He's right there.
We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular. Involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime and their
So everyone?
ability to be fair and impartial.
Come on.
In light of Ms. Reed's constitutional rights to.
Okay,
to
we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit.
Families eat
Oh, for fuck's
a
sake.
lot. Good thing there's Dash Pass. Order groceries with Dash Pass and get
I really am
$0
getting sick
delivery.
of this YouTube.
Is more
There's an
I know.
offer.
I can't.
If there
Can't
is
friggin'
some,
afford
at
it.
least a modicum.
No,
of
it's
panel
3 months
discussion
free.
between and among the jurors and counsel.
I gotta
who
find
will
that.
be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay, it's the Commonwealth's position.
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or a follow-up that's reasonable and necessary. And I understand that that has been a liberal application. And I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. it's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that. I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow. So I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it. And if you can't, I need that. You know, I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but
It's going to be a
so
act on to start with.
So let's do that. What Mr. Brennan's new to the case, what I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire. So 566 then is denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay.
12
Right,
feet.
so that,
Let's go,
Mr.
Turtle.
Clerk, 567 allowed as to both sides.
Someone's covering it, and I'm going to stream them. So I'm going to go back and forth. Once this is on break, we'll flip.
.570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. All right?
No.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe
You open the door.
harassment and distress that they felt from third parties, both
Third
on social
parties.
media and otherwise.
Bullshit.
No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed.
Really?
No third party speaks
Not
for
what you said last
the
night,
defense.
sir.
No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed.
That's a
or the
lie. That's a
defense's
blatant
control.
lie.
None.
Stop him.
There were very obviously
He admitted it
vile
last night.
acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously
And nothing was done.
In no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no
Yeah,
way
you might want to tell
connected
David to quit grabbing
Ms.
his ass
Reed or the
then.
defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself
They did.
were somehow responsible
You
for
are.
these alleged and very reprehensible things that they were describing.
Oh, the judge
in
is
one
letting it in.
notable instance,
Coming in.
Jennifer McCabe recounted being harassed by a blogger. She didn't
Yeah.
name the blogger, but she said, quote, The defense is very familiar with this person in court.
Yeah, she didn't name him
That
because
was
you
her
wouldn't
trial
fucking let her.
testimony, and she looked right at the jurors when she said it. And the very obvious overture was, you know who this is, Mr. Jackson. I was the one cross-examining her.
Yeah, you do.
You're responsible for it.
You are.
In some way, shape, form, or fashion. She outright suggested to the jury.
Wasn't that literally the
Ms.
day
Reed and the
after
defense,
Unity grabbed his
were
ass?
responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable.
Oh, you
There
did,
are
did you?
clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person for a crime that she did not commit.
Oh, please.
There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial.
And she will again.
Those individuals out there who are
no, Eva, it's not yet.
Emotional about the case, who are
Not yet.
a proponent of one side or the other. They speak for themselves. They act for themselves. They act on their own accord.
Bullshit.
They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which
They're not
also
allowed
happened,
for that.
it serves to visit an extreme and an extraordinary prejudice against Ms. Reed. Very specifically, and very
She
targeted,
created
like a
it.
laser on
Deal with
her.
it.
And it's for conduct that's completely out of her control,
Nope.
and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin.
Knew what?
They knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable.
She is.
For witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause
understand
standard,
that.
right? Okay.
But notwithstanding
Yeah,
that
quit
standard,
quoting the law,
question was,
Alan.
Was she in any way liable?
She
for
is.
that
Civilly
harassment
liable,
and
definitely.
intimidation?
Criminally
And that
liable, I
standard
think.
is extremely low.
Mm-mm.
We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here.
Did not
There's
say
no
that.
evidence that she was responsible for intimidation or harassment such that
They
they
did not
determined
say that.
that there was a no bill. And what is bothersome
Misrepresentation.
is that the Commonwealth was aware of that and didn't disclose it. We
They
didn't
can do
find out
that.
about that until in October. I
They don't
think it was
have
an
to.
October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issue?
You said when or where?
When?
When? I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide.
You're the one that
what
keeps saying
I
they're not the
believe
same
that I
case,
think
Alan.
What the court would have ruled would be exculpatory information.
It's not.
To us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I
You
have
opened
a
the
very
door.
clear memory of you opening the
Yep.
door with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open,
it's
these
open.
witnesses are going to be able to talk about it.
But I
How
kept
they-
it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling.
Too bad. Yeah, 'cause you're the one that kicked the door down, asshole.
Whatever that door was, it was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I have several times. In any event,
Stop implying
I
he's
believe that the
lying and
court
kick
should
him
make the
out for
exact
doing it.
same order this time and have a more defined. We should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it.
Yeah,
The
you
court
did.
Disagreed, and the information came in. But it's so prejudicial.
No, it
was
isn't.
so extremely prejudicial as to Miss Reed that I think we need to revisit that issue and get a more clarifying order about exactly.
Lemonade Renters Insurance
for
protects
fuck's
you from
sake.
life's coulda, shoulda, wouldas. I could have hired a plumber. Should have locked.
Step that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that
You
get a
knew the second
clarifying
you
order
kicked
that
it open.
is
We saw it on your
not
face.
admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript.
Please.
He's lying to Bev about shit Bev did. Why is she letting this happen?
And in the event, I
she's
think
gonna
the
keep
court
letting it
understands what our concern is with regard to this subject matter. We don't want a free-for-all.
Too bad.
People, one person after another, walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to misread very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed.
It is.
The one engaging in this, which is
She admitted it.
Which is just not true.
She admitted it last
we ask
night.
for a clarifying order on that issue very specifically.
Mr. Brennan.
Do it, Brennan. Drop the
Point
hammer.
out how many lies. Count the lies. Count the lies, Hank.
Do it.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me. It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so
He's calling
grossly,
Bev out
not
to
only
her
unethical,
fucking face.
but fraudulent. I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue.
Ooh.
And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to.
Good.
The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family event.
Oh my God, he went there.
It didn't happen.
He did.
And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious.
He does.
Open-ended questions, personal attacks,
baseless accusations, that opens the door. And it will open the door again, I suspect.
Yep.
And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
Yep.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
No.
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Pay attention, Bev, because he just called you dense to your fucking face.
Well, Hank just went there.
Briefly.
Sure, just give me 1 second. I want to take one note. Okay?
Of course.
Bitches. Peggy, you're a rock star. So sitting next to Peggy is Renee. I actually went to school with Renee.
All right, go ahead, Mr. Jackson.
I just wonder if where this
and played
ire
soccer with her
and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and
You did.
bashed
You did.
witnesses.
You did.
And
Yep, you did.
made fraudulent statements.
You did.
Yeah, you lied.
Was he listening?
Yep, he was.
Yes, so were
Bash
we.
A witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aiden Kearney. And they did it through a grand jury.
You did it.
And those members of the grand jury said, no.
Last
it's
night.
Not true.
Last night, he admitted to
That's what they said.
seeking out Aiden. Are you serious?
The lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard it.
Oh, fuck you.
And clearly there's been communication between Ms. Reed and Mr. Kearney. It's like, sure, there may have been communication.
May have.
It's very different from directing witness intimidation,
May have.
witness harassment
Stop
for
it.
the purposes of undermining a prosecution.
But that's what you did.
That's what they've.
That's literally what
accused
you're
her
doing,
of.
dude.
And they
That's what you did.
failed.
Documentary last night, Eva.
When they failed. Sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us.
It is.
So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and
Too bad.
We can all be professional.
I'll
We can
take
all
exception to
advocate
your
very
face. So what?
zealously and robustly. But
He
let's
said we
keep
can
it
all be
I
professional.
didn't stand up here and attack a witness.
Are you serious?
What did he say? Bash witnesses? Use this as an opportunity to bash people? But we could calm the drama down just a little bit and probably get a little further.
She needs to
All
booze.
we're
That's
asking
what
is
she
that it
wants.
not come in, and I will stipulate and agree with Mr. Brennan that this not come in the
course.
Commonwealth's case in chief. And we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close.
You will not.
We'll ask the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely.
Yeah.
Why? He lied. You know he lied. Kick his ass out.
That's what she needs to do.
Jesus Christ.
All right. The next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol
Not happening.
concentration conversion.
Yeah,
and
not
corresponding
happening.
retrograde extrapolation
Denied.
analysis. So
Denied.
who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first. And
All
we
right.
would respond, including with regard to the motion.
Okay, so Mr. Brennan, our paper 386, your number 12.
Come on. I don't want to listen to Alessi. She does need to grow a fucking pair.
I think if the neurosurgeon's unqualified, so's the environmental lawyer.
Your Honor, paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case.
It's relevant.
The statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth v. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right. Now I'll hear you, Mr. Alessi.
Oh, God.
Real quick question. Why does Karen Reed get more civil rights than everybody else on the fucking planet?
Good question.
Now,
Oh,
with
good.
Lotto.com,
We're not
any
missing much,
stolen
but a bunch
second,
of talking
any
and
casual,
circles.
mindless scroll.
Statutes that
And F-bombs will fly
discuss
today, guys. I'm pissed.
consent
Lot.
of Miss Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable. And here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up in Ipsy Dixit and saying they're reliable.
It is.
And there is a lack of the information of the factors I
In a million
just
trials.
rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth. They concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single.
Because it happened at the
report
hospital, like
of the
right.
Commonwealth.
VAC.
And we put that in Exhibit A to our motion.
We're in Massachusetts,
For
Bob.
example,
Not New York.
it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states 2 paragraphs under the chart with an asterisk. The ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
You've said that 6 times, and you went around in circles for 15 minutes
Do you want to respond, Mr. Brennan?
to say that. Yes, he does.
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Yep.
May I just respond briefly?
Sure.
Thank you, Hunter.
No.
Your Honor has often said that this is a new trial.
So
the Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial.
But you keep doing that.
That should have been in their motion in opposition.
I wish,
they should
Lou.
have put that in, assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay.
Your Honor, if you let
We have
this
time
in,
for
we don't
one
have a legal
last
way to find
motion
it.
Before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk.
What was that she
All right, so
allowed?
what I'll do is I'll see counsel at sidebar regarding scheduling.
Yeah, exactly. They wanted to drag the jurors back from the other trial, though, and they keep inciting, using the other trial. Well, in the last trial, Your Honor, we did this, this, and this. So it's like Mr. Jackson just did that when it came to like the jury stuff. Like, oh, well, we did this in the last trial, so we could start from there. Like, then unless he gets up and goes, well, this is a new trial. We can't go from what happened last trial. So it's like, make up your fucking mind, dude. It is amazing, Lou, and that's how you should order it if you go there, because it's delicious. That was about being able to talk about. Oh.
And I wanted to address something Parson said way back. It was in response to something to one of my chats. I didn't say Bev is DEI. I said she's the reason I keep getting accused of it.
Yep. Yeah, because people, make dumbass decisions like that. Like, I'm sorry, any other judge I know of would have tossed his ass. Oh, yeah, that is the sidebar. Ready? Sidebar!
I think we got a super chat. I think we got a super chat.
And that is a free Karen Reed sidebar, everyone. Welcome to the circus. Welcome to the circus! Their circus, at least.
I mean, if you're going to be a judge, if you're going to put yourself in the position of being the ultimate arbiter of the rules in your courtroom, will you fucking
Then
lay
do it.
some?
Right, then do it. Exactly. Do it, then. Do it. It's the part that gets me. Like, do it. I'm not sure if that one's going to be argued today or tomorrow. I guess we'll find out.
Well, after this, they're going to take their morning recess. Got to get those in.
It's like so ridiculous because Aiden's stuff is at 12, and according to what Hank just said, he'll be arguing a motion in that one. I'm guessing Aiden wants to be able to not be a witness or not be able to be able to still be in the courtroom. Not going to happen. Not going to happen.
Who's your friend talking to?
Oh, I don't know. I can't see. I mean, I haven't seen her since high school, but I played soccer with Renee. She was on my soccer team, went to school with her for many years. I knew her back then. She was a good person. She grew up, I'm not going to say where because I don't want people harassing her, but on the same street and bus as me for school. And she was on my soccer team for many years.
I still want to know why her right to have that lying fucking fuck as an attorney overrules John's right to justice. I feel like get it.
It doesn't, but I feel like what Hank should have told the judge was, Your Honor, last night in this documentary, Mr. Jackson and Ms. Reed admitted to not only linking up with Aiden, but to giving him all of the information. Her attorneys instructed her to do it through a third party, aka being shady. Why would you need to do it through a third party if there's something wrong with what you're doing? I think that is Erin. I think it's Paul's wife, but I can't really see because Karen's big fat friggin' head is in the way, so I can't see if it's Erin or not.
Just a general life lesson. Don't trust bitches who still wear Balenciaga.
Who the father was.
Dude,
people don't feel like
I
I'm
mean,
gonna
if
be a
you
good
look
mother because
at some of the clips of when she was a kid, dude, like just the look in her eyes alone, she looks like a crazy person. Like she's very much pay attention to me, all the attention is on me. It's like you're more worried last night about Channel 4 catching you in your pajamas. And Proctor was 100% right when he was like, do you see how crazy she is, dude? Like she cares more about Channel 4 than she does being arrested for murder too. Like you should be more concerned about your being charged with murder too than the channel seeing you in your fucking pajamas, Karen.
The other day, Elise, I did a great demonstration to prove how the tail light stuff couldn't be planted.
Ooh, I'm gonna have to watch it.
I told you about that. That was Sunday morning. It's amazing.
Yeah, you did. I was back and forth between the hospital, so I have very little. I have so much to catch up on when it comes to some of this stuff, dude. It's ridiculous.
You are muted.
I think she would be found not murder too.
When was that live, Ange? Wasn't your live was Friday, wasn't it?
I think it was on Friday.
Yeah, the Friday morning is when she went out and dropped him. Then Friday afternoon, about 3-ish your time, Elise, would be where the update was.
Yeah.
I'm gonna have to go watch it. I have so many
Do
things.
it again because I'm getting snow.
Ooh.
Oh crap! My computer. Maybe we can't do it again. I'm in on my computer. I'd have to come in on my phone. Because we're getting snow again today, and it's coming down just like it did that day. And which was just like what the nor'easter that they had. And it was pretty easy to prove that there was no way that those pieces could have been planted because you have to walk through the snow. There would have been footprints leading up to where the pieces would have been planted. And on top of that, if they would have been planted, you would have seen little holes in the snow everywhere.
Yeah.
Where they would have been sprinkled.
Where they would have went. Yep.
Yep.
True.
And when it's like I stood there with a handful of pony beads and I was just chucking them randomly throughout the yard. And the thing was, once those beads hit, they went down into the snow.
Mm-hmm.
And then as the snow melted, suddenly then the beads were visible again.
Yep.
So the only thing that they could have done was exactly what they did. Granted, red Solo cups might not have been the best thing to pick up, but I understand why
they could get,
they used it, because then you could get the snow and the blood.
Yeah.
All at the same time, setting the cup in the spot for photographs and stuff, setting the cup in the spot. But the bigger point is that if somebody would have went out there and sprinkled the glass or the taillight things, there would have been a footprint trail leading up to that.
Right. Well, now we know, right, that Karen said that John took her glass. So I always wondered why her straw was found. They found the straw from her glass and not John's. I mentioned this the other day, remember you guys? And I said, I always wonder why they found her straw, unless he took her straw or he took her glass, right? You either took the straw to use in yours glass or you took her glass. Now we know Karen said John took her glass. So no wonder why the pieces of glass didn't match the glass that John took. It wasn't the glass that John took. It was the glass that Karen took.
That's why I think that he threw one glass at the back end of the vehicle, causing the dent.
Yeah.
And then that caused her, she heard something hit it. That caused her to flip her shit and throw it in reverse, backing up and smacking into him.
He still would have had to have another glass in his hand, though.
Well, if he had his glass and her glass.
Right.
And at the impact, the other glass, the impact would, if he had both glasses in his hand, he chucked one glass at the car, fuck you, bitch.
We also know, this was a good tidbit from last night, that Karen tried to get his phone out of his back pocket. So everyone's like, I don't understand why it's found underneath him. How could it have gone underneath him if he was hit, blah, 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 blah. And in the very beginning, I said, well, it could have been in his back pocket and just, slid out. But now we know that it was in his back pocket the entire time.
She rolled him over.
Karen tried pulling it out, and that's why it was found underneath him, because she pulled it out of his pocket. She was trying to get his phone. So Deb said, question, it would be prejudice for Karen Reed to be in an orange jumpsuit in front of the jury, but isn't it also prejudice for her to cosplay as an attorney? Jury needs to know she is on trial here. So defendants do end up in their orange jumpsuits or whatever color, black and white stripe that the jail in that wherever they're in has for uniforms. A lot of them do their whole trial in their jail uniforms. So it's not prejudicial because 90% of people tried actually are coming in their prison gob, unfortunately. But make no mistake, it is not lost on the jury that she's sitting there with the laptop, blah, 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 blah. Like a lot of these people have either watched a trial, have been a juror before, like they know a defendant doesn't normally sit there on their laptop, right? Like that's not normal behavior. And what it tells the jury is that she has very serious control issues, that she can't just let the attorneys do their job. She has to try to do it for them. And that's something that screams out to me and has, like, in my mind, almost pinpointed the time, and I talked about this yesterday, when she tried to control what was being said on my channel. And it's like that red flag keeps popping up in my head every time I see her on that laptop, because it's exactly that, a control thing. And she did say on that documentary last night, she's a little controlling. I would say a little is not the right word, but whatever, like, is what it is. But I mean, the amount of people who are still saying that the taillight was planted is ridiculous. Because like Ange said, you couldn't have planted it. There would be marks in the snow. They recorded the whole thing. And the car wasn't even in Canton until the CERT team was already on scene. Proctor could not have planted it because he never went to 34 Fairview. And now Aiden says it wasn't Proctor after a year and a half of saying it was, that it was the other guy. Yeah, it was the other guy. It was not Proctor. It's like, if you guys aren't picking up, if Free Karen Reed is not picking up on these things, right, where the story changes to, based on when they find something that says it couldn't have been possible for what you're saying to have happened, they then switch gears to something else. Well, that's not what happened. This is what happened. Truth doesn't change, right? I think Karen said something last night along the lines of, I was just trying to see if, like, my story worked. Your story? Yeah, it's a break, Anna. Your story. Well, the truth isn't a story. It's the truth, right? Like, yeah, that's the thing.
Well, maybe for her truth is the story.
Exactly. And that's another thing. Like, her saying, like, that documentary was her testimony, like, why not just testify then? If you have nothing to hide and you're willing to say anything that there is to a documentarian, why the hell not say it on the stand? Why not?
Because her truth is the story.
Right. You have nothing to hide. This is the way you testify. Or you could just actually testify. You could do that too. Because I'm going to tell you right now, if I was innocent and I had nothing to hide, I'm getting on that stand. I don't give a shit what my attorney says. If I have the truth and I can explain everything that happened in a way that it happened, I'm doing it. Like.
So are they thinking for some reason, because the Dateline NBC interview didn't come in because NBC was stupid and trashed their masters, that the one ID played last night wasn't preserved and won't come in?
I don't know yet. I have no idea yet, but I do know this. If anybody believes that ABC actually trashed their masters, then fucking people are delusional. I don't give a fuck what anybody says. Everybody keeps all their unedited footage. They don't trash it. They all have it. They just don't want to give it up. It's that simple. Like,
I have my masters from music videos I made in 2003.
They have them. Like, they're just not wanting to comply. It is what it is. They're out of state, so there's like a little bit of a hiccup when it comes to legality out of state and whatever. But I mean, if I was Hank, I'd be pushing a hell of a lot harder, especially with this new ID one, to get it all of it. It makes her look terrible, and it's, I think, 5 parts, I believe. Like, Eva said, did you hear her last night say, I couldn't go near the family and didn't go to John's funeral? Well, she didn't go to John's funeral because she had to stay away at that point, but I just had to put him behind me. Yeah, she talks about John as if he's not an actual human being. Yeah. It happens almost every time she does any sort of interview. Everything is about, she says, this happened to me. So, yeah, it is the Karen Reed Show because it happened to me. No, you happened to everyone else. You, Karen, you happened to everyone else, including myself. Like, you caused all of this. All the harassment I still receive, all the harassment any person has received who stands up for the right thing or is willing to speak out, like all of it is your fault, Karen. Yes, that is a burden you absolutely should have to bear, you and your shitty ass attorneys. 100%. And I have to think that during that sidebar with Bev, that Bev said, Karen, if you want to keep these attorneys, you're going to have to sign the waiver that says that you're not going to appeal on grounds of ineffective counsel. I fully believe the judge will make her sign that, because you want to keep these attorneys after what I've concluded, then you do so at your own peril. You know?
Can someone please show me where, I mean, maybe this does exist in Massachusetts law. Where does she have the right to hire a lawyer that lies to the judge just because she fucking wants to?
Yeah, she doesn't. That's not how it works. I love when people are like, she has the right to have any attorney she wants. She does not have the right to have an attorney that is not lying to the court. The court has every right to eject that attorney. It's preserving her right when you do so.
She fucking argued with him from the bench 10 minutes after she said, don't lie to me again.
And he did, over and over and over.
And she told him, and she did nothing.
Nothing. And that's what pisses me off, is she consistently does nothing. And it's like, okay, cool. You can sit there and argue like that, you know, he's arguing his case in the way that he thinks is the best light. But she was very clear. I don't want any more misrepresentations, false facts, like none of it. And I'm not going to put up with it, except that's exactly what she did right after. And we knew that's exactly what she would do. If she does not do something here, and I don't give a fuck if it's some sort of sanction where you sanction him in front of everyone on planet Earth and give him a good stern talking to, because, you know, I feel like that's basically all she's going to do. She's got to do fucking something. I think at the very least his pro hoc should have been pulled. You know, I know that she has a duty as a judge to keep the trial on track to trial, but you can't do so at the behest of an attorney lying to the court and not having candor to the court over and over and over and over. Did you really think you telling him you're not going to put up with it is magically going to make him stop? No, because you've already kind of alluded to that numerous times before, and yet they have just continued to spit in your face, Your Honor.
Call this sexist, call this misogynist, call this misandrist, call this whatever the fuck you want, but this is my opinion. If you are going to be a judge, grow a fucking pair.
For real. I agree. I highly agree. She does need to grow a pair, because all she did was open this up for any other attorney from Massachusetts or Pro Hoc BJ to come into her courtroom, act this way, go over the line, not just toe the line, but go right over it, all the way up to her face, spit in her face, turn around, kick the door down, come back, kick the door in, spit in her face again, over and over and over, and she ain't gonna do a goddamn motherfucking thing about it.
If you want to commit murder, forum shop to Bev, because the Superior Court Chief Justice isn't gonna do jack shit to stop
That's what she just told the world. That's what she just told the world. You know? Oh my God, that's a good point, Lou. Lou said because she was intoxicated, do you think she thought it was in drive? Imagine. Oh my God. Nah, I do think she knew.
I believe because she was intoxicated, that's what, because your inhibitions are blurred at that point. You have very low inhibitions and your impulse control is very low. And I believe that, this is my opinion, of course, but I believe that because she was so drunk, she threw it into reverse and then hit the gas because she backed up at a high rate of speed.
Yeah. Yeah. That's the thing, right? That's okay, Parson.
And even if she had claimed, you know, oh, I was so drunk, I thought that the R was a D. Okay. You're from Massachusetts. You're driving in a blizzard. How many people punch the fucking gas?
No one. That's the other thing, is that it's like snowing. No one. That's why I said yesterday, like, no one who's a happy person, no one who's not really pissed the F off is gassing the gas at 75% pedal. You have to be pretty pissed off to jam your foot on the gas and almost floor it right away. You know? insane. Like,
Oh,
so, I
Lou,
mean,
I think she should be found guilty of murder too because of the
yep.
casual disregard. Do I think she will be convicted of either? No, not for a second, not anymore.
I think she'll be convicted. I think there's a very good chance she's found guilty of something, one of the 3 charges, if not more than one of the 3 charges. Remember, we don't need to prove intent for murder 2 in Massachusetts. We don't need intent. So all you need to
Can we just
prove is
fast forward to that part, please?
what? Which part?
Where we get to the murder 2.
I
Can
know,
we
right?
just
Where they
fast
read
forward?
out
Can we
the
just like bypass all of this stuff and just get to the
wasn't it
crux?
like 28 days or something we did last time? 28 days of trial, like 28 fucking days, dude. It's a long trial. I'm hoping by cutting some of the nonsense out, and I think that's why Hank is cutting Aruba, where I think it's relevant in a way where it shows she flies off the handle and makes up stories in her own mind. I think it could be cut without really, you know what I'm saying? That's a couple witnesses you don't really need. Like,
Aaron, I do think that the 21 Lexus did have a bump stop. I think they've all had them as part of their standard safety features since 2018.
yeah. I mean, that's the other thing. If she's still going to go, and that's, people don't realize that either. Like, she's conflating a third party culprit defense with a Bowden defense. In a Bowden defense, you don't have a constitutional right to argue a Bowden defense. So she's using sort of both, you know, part third party culprit defense and part Bowden defense. And a Bowden defense is basically like digging into like a shitty investigation and harping on the things that were not done right. But in a Bowden defense, you actually have to have like something that shows that like they had another person that could have done it and they just like didn't look into it, willful like disregard of not looking into it. And that's not the case here. So
Right.
I
That
don't.
doesn't mean they have to investigate people they know didn't do anything.
Correct. So it's like, I think Hank is also going to make sure that the judge puts a pin in them trying to put a Bowden and a third party culprit defense together for this case. It's just not going to happen, you know?
Oh, I'm so disillusioned with everything that she's done so far this morning. I'm sitting
know.
here fully convinced Aiden, despite being a witness, is going to be in that fucking box every goddamn day. But the Alberts and McCabe's are not going to be allowed to sit in the closing to defend themselves against the lies that the defense tells.
I don't think that she'll keep the Alberts and McCabe's out after they testify. For the closing, I don't think she'll keep them out. But
She obviously has no intention of keeping the goddamn witness out of the press box.
Well,
No.
that's the thing. He's on the witness list, so he doesn't really have a choice. He's sequestered as a witness. And as you notice, the defense did not argue that he should be not sequestered.
But he was there.
He's there now, but this is pre-trial. That's why he's there. It's
'Cause
not
it's all
trial,
still
it's
open.
pre-trial.
Any witness could be there during pre-trial.
Mm-hmm. Yeah, not
Doesn't
till trial
pre-trial also include jury selection, which would completely erase the whole point of trying to protect the jury from him?
No, that starts trial. Jury selection starts trial.
Jury selection's what starts the trial. These are these are pre-trial motions and all
These
this
are
stuff. that happens.
pre-trial motions in limine, which are like the last sort of ditch motions before you start trial. So he's only allowed there right now because it's pre-trial and not trial. Like, I mean, I guess in a way, pre-trial includes part of jury selection, but usually they consider jury selection the start of trial, not the official start of trial, because the official start of trial would be like the first day you have someone testify. But a lot of the time, jury selection is like the start of trial. And even during jury selection,
Once the jury's seated, then the trial starts. You have to seat
Right.
the jury.
right,
So
once
you
they're
can
all
get-
seated, you know? So it's going to be, once the jury is picked and seated, then he won't be allowed in. But jury selection is going to be with a lot of different jurors anyway. Like, I mean, a lot. Like, and I think last time we had 20 jurors. I think we're going to need more than that because we almost ran out of alternates, if you guys remember. We almost ran out of fucking alternates last time. So that would have been bad. We can't have that this time.
I wish, and it may come back, but I wish I had any faith in her.
I know. I know. I don't have a ton of faith in her, but I also know, like, legal wise, like, she has pretty much like followed the legalities of what she can or can't do, with a couple surprises. But like, normally, if there's like a high legal concrete reason to say no or yes to something, she usually follows along that bound. So it's pretty easy to guess what she's going to do on most things. Some things, not so much. I still don't understand why. I mean, Hank asked for it. I get it, but like, too little, too late on the gag. You know, too little, too late on the gag order. Like, it was just way too little, too late. Like, Freak said he's holding on to your faith in the case. You can have it back when you need it.
Okay, you know what? Freak and Parson, you two hold on to my faith for me.
Yep.
I may
For
need
real.
it back, but I may tell you to just dump it in the garbage here in a couple of weeks.
Right. I think
just-
that's another thing. They need to make the buffer zone bigger.
I wish I believed she gave a fuck about anything other than pissing Aiden Kearney and Alan Jackson off.
Yeah. Yep.
I'm beginning to wonder if the rumors about this judge are true.
I mean, here's the thing. She was a defense attorney before.
She's already got a defense bias, and she's clear with it, and she's not supposed to have it.
No, I mean, no judges are supposed to, but they all have a bias about something. Let's get real. Either they lean heavily for, you know, defense, or they lean heavily women or men, or, you know, whatever. Like, there's a reason why people judge shop when they're not supposed to, including Aiden and his attorneys. They love to judge shop over there. That's like their favorite thing to do. That's another thing. She's the, you know, head justice over there. Nip things like judge shopping in the fucking asshole. Aiden and his attorneys have been pretty blatant about their judge shopping. Stop letting them do it. Stop. Like,
sidebar question.
Sidebar question? Where?
Sidebar question. Are curly fries acceptable breakfast food?
Yes. Curly fries are acceptable food at any time.
Okay.
Because they're amazing and delicious.
Well, it's only 9:15 out here and I'm starving, so I'm going to use the 11
I always forget there's like a 3-hour difference or 2-hour difference. But it's only 11:15 here, and I would still eat them at 9 a.m. Just saying. If I had curly fries, I would make them.
They're
They
in the
sound
air
delicious.
fryer, so I'll pass you some virtually.
Right? Virtually, I'll take any food. I have shit in my house right now because I am a poor person, and the hospital is a lot of fucking money, dude. Like, transportation when you don't have a car is a lot of money. You got to pay for Ubers and Lyfts and Jesus, the amount, like, it's absurd, dude. Like, and
how far are you from the T?
there's no, not where I am.
Oh, you don't have the T near you?
Mm-mm.
Oh, damn.
Nope. And you got to think I'm an hour away from Boston, where my kid is in the hospital. So,
oh, I didn't realize you were outside. I thought you were right in the city.
No. And so the back and forth for that. Well, riddle me this, though. Riddle me this. For a hospital, okay, that gets, and all the Boston hospitals, because they're good hospitals, get millions and millions and millions and millions of dollars in private donations just given to them, okay? Given to them by celebrities and rich people. It just given to them. But riddle me how they only cover, if you are inpatient with your kid, they only cover one $7 voucher per day for a lower income family to feed the person who's with said child. $7. That doesn't even pay for a drink and something to eat in their cafeteria. And that's where you have to use it. $7 per day, one time. What? And also, this is the kicker. They charge you for butter packets and sugar packets. I kid you not. It's like 10 cents, 15 cents per packet. Like, I'm sorry, but for hospitals that get that amount of money given to them on a constant rolling basis, I think you have to do better than having a one time a day $7 voucher long term when you have it. It's not like your kid's there for one day. You're talking weeks, months at a time.
I would be talking to social work.
That's it. That's all they can give you. Believe you me. I've basically lived at this hospital my kid's entire life. That's all they'll give. That's it. That's it. Like that's absurd. That's like absurdity. Like I have now decided in my mind that is something I'm gonna fix somehow, some way. I don't give a shit. I'm gonna fix it somehow. Like, because that's just not okay. Like, I'm not the only, poor family on planet Earth that has to decide between eating while you're at the hospital with your kid or putting food in your house for your other kids. Like, nobody should make that, or transporting there and back on however many days they can afford and back and forth. Like, no one should have to decide that. No one. And for a hospital that has the amount of money that they do, there's no lack of money for them. Like, that should not ever be. And now, this was a good one. Now they want us to go see a scleroderma specialist in Pennsylvania. Pennsylvania. They want us to go to Pennsylvania. I'll just, hop on my Nikes and pull all that money out of my ass I don't have and get right on over to Pennsylvania.
Get on the Subaru Express.
Yeah, the Subaru. You know what I'm saying? Just hop on them Subaru. I'll get there in T-3 months. It's fine. Like, just pitch a tent along the way. Like, what? Like, yeah, I mean, I'm going to do it, obviously, one way or another, because, like, my kid needs it. Like, she's not getting better. She's getting worse. And, like, she's now been diagnosed with scleroderma, which is part of the hundreds of other things that are going on with her disease. But what the hell? Like, now I have to somehow figure that out and pull it out of my ass as a parent. Like, it's insanity. Like, it doesn't make sense to me. Like, this is where, like, rich hospitals should be like, oh, hey, we know it's probably not feasible for you to pay for that, so let's try to find funding somewhere to help with that. Like, that's not, like, Epilepsy Foundation and places like that have, like, help because, like, your kid's an epileptic or your kid has cancer or your kid has whatever, right? Like, like, my kid doesn't have that because her disease is not widely known. It's very uber rare. We're talking less than 200 people last I checked in the entire world, not in the United States, but the entire world. Like, so there is no, like, foundation, that helps with costs. I think I am. Yeah, I am on the live feed as far as I know. It is effed up. How do they judge shop? Well, this is what they do. They file motions and they wait to file them until they know a judge is on that. So judges have rotations, whether it's a week or 2 weeks or whatever. So they wait until that specific judge that they want is on the rotation for that motion. So they'll file that motion when a judge that they want is on rotation to get that judge. They should never be told who's on rotation. Judge shopping is not actually legal. It's just something that they, lawyers try to do behind closed doors and find ways around. And that is the way that they have found around it because the Supreme Judicial Court likes to give who's on what rotation. I mean, it just makes sense to me why they do that at all.
Yeah. At this point, I think if they asked Judge, hey, are you on rotation Tuesday? She'd tell them yes.
I know, right? I mean, really, realistically, like, why are you telling anybody when you're on rotation? That's just great. Yeah, it's live. Short break my behind. Yep, I'm all the way to the end here. This is not a short break. This is a very long break. Get in the suitcase, Sarah. Sarah Boone, yeah. I mean, that's the thing. Like, if you're going to be a judge, you're going to need to, like, buck it up, Buttercup. Like, you're going to have to stop allowing the bullshit in your courtroom, because make no mistake, like I said, if it was the Commonwealth that pulled this shit, we'd already have mistrialed this fucking case. Like, prosecutorial misconduct is what they would call it. So I don't really understand why it's appropriate for the defense to just do it. I don't know any other judge that would allow it, to be honest.
Because
It's
Joshy
amazing.
told her to.
I know.
Oh, wait, did I say that out loud?
Right? What the fuck? Like, so that is the answer to that question, Roasgate. That's how they legally judge shop for judges. The only time that they don't get to is when you get, like, you commit a crime and you get, like, arraigned, kind of like Aiden's has no choice over who the judge is today because he's being arraigned on the new witness intimidation charge today, which I'm going to cover both, or I'm going to attempt to cover both, you know, hopefully. Also, if you guys didn't hit the like button yet, can you hit the like button? I really appreciate it. Or if you could share my live stream with people who might not have discovered that I exist yet, that would really help. And if you can donate to the channel, which always helps because we're a tiny channel and we run off our donations from our viewers. And you can do it with this thing. There's a ticker at the bottom that scrolls. It's very small. I cannot make it bigger. People ask me all the time. I wish that I could. I cannot. But here's the bigger one that I can pop up on the screen. And you can donate through Cash App or Venmo or PayPal. And people like to, like, write witty comments or give some words of encouragement, or sometimes they don't write anything. They just donate. And I'll read them because it's my way of saying thank you. I don't read people's real names because no one on planet Earth needs to be harassed. I usually read their screen name, but I don't read anyone's real name, anybody's government name. And there will be comments that people don't want read. You just write ANON or A next to it if you don't want me to read it. I know, right? That's what she said.
Ange will understand where my head is right now. Not only is Aiden's bond not being revoked, I can see the judge actually completely dropping the charges and saying, oh yeah, Ring is illegal wiretapping. And I think Betty is being sent home from Tennessee tomorrow with a fucking gift basket. That's where my faith in the justice system is.
Well, it's an arraignment, so he's definitely not getting his charges dropped. This isn't this is just an arraignment. And B, there's very clear laws around cameras for businesses, and because where Chris Albert's business is a public sidewalk. It's literally, and I kid you not when I say, like, it's on a public sidewalk. So Chris's pizza shop, like, you have to walk onto the public sidewalk, and then it's like it's in the center of town. So there's, like, businesses right and left of him all across things. So it's literally on a public sidewalk. So he has one camera outside and one camera or two cameras inside. And I believe it was the inside camera that actually picked up the audio. It could have been the outside. I think it was the inside. Oh, the inside though. Either way, it's fully legal, and you don't have an expectation
so
of
Mr.
privacy.
Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago.
And it'll still be denied. That's irrelevant.
Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal,
they are not.
and were to take some action on count 1
They will
and
not.
count 3, for instance, either dismiss it or take some other action and remand down to the trial court for.
What's wrong with these burger buns?
They will not.
They taste perfectly delicious,
Just
but due
wants
to a
to say
production
this out
mishap,
loud
their bottoms are slightly curved instead
to
of
rile up his
Jeopardy
base.
attaches if there were to be some action taken on count 1 and count 3. For instance, those counts were to be dismissed. We would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because that's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ.
Then make your
And
motion to
jeopardy will have attached, and the entire
dismiss
case would go away.
if that becomes relevant.
Ergo, we
They already
believe
did. It's
the
denied.
best practice for the court would be to continue the trial
4
for
times.
purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I
Nope,
did.
not
I
gonna
don't.
happen.
I do
Denied.
have
It's gonna be
a
denied.
generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be to you 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
It's going to be
All right,
denied.
Thank you very much.
Anyway.
Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Handle it,
Good
bruh.
afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit.
That's it.
The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The
So he lied.
respondent's brief is due
Okay.
Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal. Know which charges are going to go forward and which.
No.
At the same time, Commonwealth is obviously strongly opposed to moving the trial.
Nope.
And so,
Nope.
while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule, that would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury.
Yep.
So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
Come on, man.
Well, they got to get over to Aiden's court next.
Yep, 12. But there's so many other motions in limine from the Commonwealth that they still need to do. So it's like, why'd you start with the defense's motions in limine? Why didn't you start or go back and forth? You know what I mean?
And we all know Bev only likes to do half days.
Yeah, like Lou said, no more fucking half days, dude. It's absurd. I've never seen a trial do half days a day in my fucking life. Not a day in my life.
I do like how he said that they should speak with the victim's family.
Yeah, well, that they're supposed to, you know? Oh, yeah, she called into the glare and sounded like an idiot. How mad on a scale of 1 to blow a gasket do you think Aiden was? He didn't get the first. Not only did he not get Karen's first interview, because like that went to like Vanity Fair and like all the other little small interviews she did, but like he didn't even get the first social media one. Nah, which she promised him.
Karen called into glare?
Yeah, yesterday.
Shut the fuck up.
They did like a 12-hour fucking
marathon. That's right.
Yeah, a make money for Karen marathon. Like, and she went on his show, and it is desperate. It's extremely desperate. I'm sorry. Do you see this woman in front of you, everyone? She doesn't need your money, okay? She's not poor. She doesn't have rent to pay, right? Like she's wearing $1,000 shirts. Like if she needs money, she can sell. Oh, did she say she sold her shoes, which we clearly know by looking at her shoes. You didn't sell enough of them, obviously, did you? Because you're still wearing over $1,000 shoes. So.
God, she looked at us like she knew we were talking about her.
Yeah, I know. Yep.
And not only is she the bitch that is so unaware that she still wears Balenciaga, she can.
Yeah, exactly.
She doesn't need your Social Security, honey.
No, she doesn't. And it's like, it pisses me off because I was saying this the other day, like I see so many other families while I'm at the hospital that are low income
So we'll see
like
everybody
me that
back
could use
here
that
tomorrow,
fucking
but
help.
Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with
Wait,
maybe Mr. Weinberg. or
Thursday?
counsel.
Yeah, we're done.
So see you Thursday. All right. Thank you, everybody.
So no Wednesday then.
Nope. And absolutely zero justice for John.
Okie dokie then. Now this is where I look because I know I want to see if they're going to stream Aiden's hearing or if it's just going to be Zoom. I'm hoping the camera goes over to if it's going to be in the other courtroom.
Maybe NBC 10 it'll do it.
I'm going to look right now and see if I can find, let's see. It's an arraignment, so let's see. Nope. Nope. Nope.
I just keep thinking about that first interview that her father came out and said, oh, it was a tragic accident.
Yep. Yep. I mean, the stuff that we saw last night in the first part of that is the reason why she got on the Glare show was they were doing damage control ahead of time because TikTokers had been able to screen it ahead of time. IG Discovery had TikTokers stream it ahead of time. A lot of them actually being like, you know, free Karen Reed streamers, which is hilarious to me. But nonetheless, that's what happened. So ahead of time, they knew it was not going to be great for them. So they decided they were going to start trying to do damage control. And what Karen did was basically say like, oh, well, the relationship that I had with the director broke down and she was supposed to be a fly on the wall, but she was more like fly in ointment. Like what? Like what the hell?
Oh, that doesn't sound good.
Yeah, like what the hell? Like, and that was damage control. That was trying to get around the fact that they knew it was not going to be all rainbows and butterflies. No offense, but it's her own fault. Like, it's her own fault. Come on.
When you have to do damage control because of the words you allowed to come out your own damn mouth, you might be a liar.
Exactly. Exactly. And that's the problem that I have, which is she literally said all this shit herself and then realized afterwards that it didn't sound good because she has such a lack of self-awareness that she refuses to understand that she sounds like a narcissistic piece of shit. She thinks it sounds good and it does not. So yeah. I don't see it anywhere
Well,
yet.
yeah, she's trying to impress everyone. She wants to make it all about her. It's all about her. She did this. She did that. She can do whatever the fuck she wants because she's Karen Reed.
Well, that's it, you know? Like, you know what? I want to do it.
Do you have the Zoom link?
I do. I have the information for it.
Well,
the
if we're gonna
problem
do
with that
Zoom-
is
Hold
I have
on.
no way to add it here.
If we're going to do Zoom, then we have to be really careful and we all have to stay muted.
Oh, yeah, I know that.
And no matter what, you can't unmute because we do not want to be heard on official court transcripts.
Yeah, no, I know. But I don't, that's the other problem is I don't have Zoom. So I don't know how I would add that to the screen.
Well, you would type in the link and then you would open it from your browser.
Oh, hey, Sunny's here. Hey, Sunny.
In the link.
Hey, hold on one second. I'm trying to. Can you hear me?
Yeah, all right. So it says arraignment session. Here's the number to it. And then, so it's like phone. This is the information I have is for the phone.
Well, you would have to call in on your phone and keep your phone muted once you're in.
Yeah, let's see if we can. I don't even know if we're going to be able to pull this off, but we can attempt it, you know. If we can't, I know someone else that should be streaming it, and we'll just stream that. But let me get a pencil
Oh,
here.
can we make merciless fun of him while we do it? I haven't done that in months.
Yeah, duh. He thinks that you can't say mean things about him anymore because he's a witness. Ha ha ha! Ha ha ha!
Oh, no, I meant Tom.
Oh, Tom. Yeah, I don't know if he's going to stream. I don't think he even knows how, to be honest. Yeah, it's not a meeting ID. It's a number, the 866 number, and then it's 1061489 pound. So I'm assuming it's just the information for the phone. Let's see. I'm going to attempt it. It might already be full, though. That's the other problem, is it often will get full.
I will say that Tom's desperation to be relevant again is rather yummy.
I mean, I have not watched him, and I don't even know how long, but didn't they, like, all turn on him at one point?
Yeah, because he busted him out over the whole fucking fight about money on a hot mic.
Wait, what happened?
Oh, you don't remember that?
I didn't watch it. No, what happened?
He got picked up on a hot mic talking to Nick, was it? Or it was somebody.
Yeah.
Got picked up on a hot mic talking about why Nick and Aiden shouldn't be getting into it over money because there's more than enough for everybody to go around. We made sure of that.
Oh, wow. That's, yeah. Yeah, of course, he got a different car and shit, like, that he bought with that money, and it's like, bro, that's blood money, okay? Like, as everybody can see, I haven't even made a single penny today. I've been on 2 hours, 37 minutes, I haven't made a single penny. It's not always about the money. Also, it's helpful, you know? But, like, people like Tom, like, he wasn't struggling. He wasn't struggling, you know what I'm saying? He wasn't struggle busting it.
One of the things that I really, really appreciate about Tom's desperation is Dinah draped all over Karen at her birthday party, and Tom wasn't even invited. I can hear whispering.
Why isn't it?
I think she's trying to get into the meeting.
I am. I have to reset my phone, though, I think, because it's not working on speakerphone, and you guys won't be able to hear it, so. I only have the number. I don't understand. I feel like it should be streamed somewhere. Like, I feel like it should be video somewhere because Hank said something about emotion. I just feel like it has to be. Let me try Court TV and see if there's anything else. Or Channel 10, I already tried, but I didn't see it.
I think part of the reason that I am so disillusioned with what she did this morning is that
Yeah.
Hank is too.
Okay, girls, I just got caught up and I am like boiling pissed right now. So I haven't been able to hear your commentary on it yet. So I'd really like to hear and be able to vent myself, but I cannot with this judge. Like, I have given her so much grace and so much credit, and and Hank is doing he is like doing the work of 17 armies, and she is just.
Yeah, pretty much. You conked out for a second, Sonny. Did you accidentally? No, you're not on
To
mute.
the left, to the left. Oh, I bet her
Yeah.
screensaver got her.
Oh, maybe. Yeah, it didn't mute her. She didn't mute it. It's not muted.
Yeah,
So when the screen turns off, it stops them from being able to communicate. So she'll need to turn her screen back on and get rid of her screensaver.
And she won't know that until she takes it down and pops in and has everybody telling her to turn her screensaver off.
Yeah, I didn't know that. I didn't know screensavers did that. My freaking stupid phone.
What are you talking about?
Screensaver. You were talking and it just conked out.
Oh, I'm so sorry.
In the middle of you talking.
But like, what? I swear to God, I'm at the point right now where I'm like, is she in on this innocence fraud? Like, what is going on? What is going on with her?
A couple of people have said that to me too, and it's like, what is actually going on here? Like, I mean, I get it. I get a judge's duty to make sure that the trial stays, you know, on track, but at the same time, you can't just allow attorneys to keep lying to the court and not having candor and then just doing nothing about it. Like, that's just, what? Like, no.
Like, they have done the most egregious
Yep.
perversion of justice in the American judicial system in
They have.
present time jury trials in the history of American jurisprudence. And she is just allowing it. She's saying, yes, you committed criminal acts in my courtroom all the way up until, oh, and including right after I admonish you right now, you're going to do it again. You're going to lie to my face again. And I'm going to just keep fucking allowing you to lie to the court to try to get a murderer of a Boston police officer free. And I'm going to just keep letting you do it. Like,
But it's okay, Sonny, because Karen said she's fine with them doing that.
She's fine with what? She's fine with what?
She's fine with her lawyers lying. She has no problem with it, so she gets to keep them.
Oh, yeah. As long as it's okay with the murderer, then let's go ahead and,
Pretty much.
Let's make sure it's okay with her. I mean, here's the thing is, like, I get it that you're trying to protect, like, appeals, but Judge Cannoni, this bitch is going to appeal no matter what happens.
No matter what.
Yeah, like, you cannot protect. Who in the history of criminal defendants has not appealed their conviction? Like, come on. You cannot. There is not one supreme. They have appealed to the state court, to the Supreme Court, to the federal court, and they have been denied every step of the way. And now they're postponing this thing because they have another fucking appeal that everybody, even people who are on Karen's side of these law tuber grifter assholes, they're saying this is a waste of time. It's like, oh my God, I can't. I want to punch people. If I was there, I would be in I would be in prison myself over this shit. Because I cannot believe how the O'Keefes and the McCabe's and the Alberts and, I mean, how in the
Own reputation than she is in
so much
pursuing
grace.
justice.
Oh my God. The grace that they have. I mean, I can't. I am more pissed than I'm just as pissed as I would be if it was my own damn family.
Right.
I can't. I don't get this. I want to cry right now. I was so excited for today.
I did not even know she was gonna, like, it was very like last minute, like, that she like wanted to address this right away. It was like, what? Like,
You're muted on your end of your phone, right?
Me?
You're muted on your end of your phone, right? So that they don't end up hearing us. I get really freaked out because we did this one other time on a Zoom, and there was people promoting their YouTube channels. Duty Ron had a hot mic moment. It's just, and we don't want to disrespect the court. The court's already been disrespected enough by all of this, in my opinion. So I'm sorry if I'm a little bit of a nervous Nilly about all of that.
I agree with Ange.
It's muted.
Well, watch it. What got everybody then was a break. So watch that they don't unmute during breaks, because that's how everybody got caught. But myself personally, am I worried about preserving justice in this courtroom? No, because the judge doesn't give a fuck.
Well, it's a different.
So why do I?
But I don't want to be part of an official court transcript, and I don't want to be a podcast that I'm on as part of an official court transcript.
Well, there's that.
Not good for us.
Guys, can I ask you why Hank, this is the one thing I didn't understand about Hank this morning was, why didn't he pursue more doggedly this consciousness of guilt with the witness intimidation?
Because that wasn't for that. That wasn't for specifically that. That was the defense's motion to keep out, harassment and unrelevant, blah, blah, blah. It wasn't for the consciousness of guilt or joint venture.
But aren't they presenting that in trial? Like, aren't they going to use those things, or is it just like they don't even present that information? I'm confused.
No, as far as I know, he's still trying to do joint venture as a consciousness of guilt, but that would be separate and apart from allowing it to be talked about like throughout the trial. Right? They're trying to keep it out from being like talked about like throughout the entirety of the trial, other than just at the time when it is for that.
So do they present that at the end? Like, do they actually present that to the jury in evidence, or do they just give them a reading? I don't understand. Like, are they going to bring?
We won't know until we get into trial.
Yeah, that's more up to like what the judge allows, unfortunately.
But let's say that they approve the consciousness of guilt. What would be so they go through the whole trial, and then
So what will happen is the judge will stop the trial and say, what you're about to hear is consciousness of guilt. She'll give an instruction to the jury about how much weight they can put on it, how much weight they cannot put on it, what they're hearing it for, that they can or can't consider it evidence, that they get to decide how much weight it holds, and that it's just for the purpose of showing consciousness of guilt. So the judge is always very careful to do the whole spiel before they do it, before they do whatever Hank's planning on doing, and then again when the jury goes back, to give them the same instruction again about it when they go back to deliberate.
So when she says what you're about to hear, can Hank then, like, does he present evidence in the open court as
that?
like,
Again, that's got to be up to what the judge agrees he can or can't do. So normally, yes, the jury will hear something. We don't know what. We don't know if they'll be allowed to see chalks, or if it'll just be a couple questions or a witness. We don't know. We won't know until that's ruled on, what he's allowed or not allowed to show. But he will be allowed to do it in front of the jury.
okay, and in front of us, the public?
Yeah. Yep. Because you wouldn't give a consciousness of guilt jury instruction unless it's going to be in front of the jury. And if it's in front of the jury, it's in front of us. That's a public trial. So it can't be in front of the jury if it's not in front of us.
But I just meant, like, if it's a jury instruction, because those are different. Like, she would just say,
she'd have to give the instruction if he's showing consciousness of guilt, though. And usually when that happens, they stop and they explain, like, what you're about to hear is going towards consciousness of guilt, and there's a whole spiel that goes with it. So normally, like, you're not going to get a jury instruction on consciousness of guilt if nothing was introduced in the trial that would show consciousness of guilt. You know what I'm saying?
okay. So he's not even going to try to bring in any. Well, they can develop that, or are they hamstrung on that?
What? Develop which? What?
Like bringing in any kind of witness intimidation factor.
So they're going to have, that's what they have to talk about today, and they'll address it Thursday, but they have to come up with some parameters of what kicks the door open to allow it in, like they did last trial. Last trial, Jackson allowed it in by the questioning that he was questioning the witness with, and it was allowed in. So I assume it'll be along the same lines of, it's not allowed in unless someone opens that door. And then if they do, whether it's the Commonwealth or the defense, it will be allowed in.
Okay, so Hank can introduce that through his own witnesses. Like, he can develop it, like she allowed them to develop third-party culprit. He can develop
sort of.
that?
It has to be an answer that's coming from a witness that's natural. Like, you can't like solicit it from them. Like, it has to be something that they're going to naturally say to an answer to a question you're asking.
Okay.
So.
But he could ask a question with that in mind.
No, he can't ask a question directly about that. No.
Okay.
That's not going to be allowed in. It'll only be if they ask a question about something and then that person answers it and mentions it, or it has something to do with the answer,
Okay.
Then this door sort of gets swung open for that, and now it's in.
Okay. I feel like the state is really. Why is this Massachusetts like so criminal friendly, or what?
Yeah, it is. It's very unfriendly to victims, and they don't do a whole hell of a lot to protect victims. I'll tell you that much. It's really frustrating. because it just shouldn't happen. Just
I
shouldn't.
mean, it's outrageous.
Yeah. Oh my God, Howard, you are totally right. He is. The sewer turtle is a crash test dummy. It's amazing, right? He is a crash test dummy.
And he's still in the courtroom. I mean, it's so
It's
disgusting.
pre-trial. I was explaining that earlier. It's pre-trial. That's why the trial hasn't started yet. He's a witness. He's on the witness list, but he can still be there pre-trial. Anybody can be there pre-trial. He just can't be there after the trial starts.
Yeah, no, I get that. I'm just disgusted by the fact that
Oh yeah.
he's there.
I don't know why the judge didn't just remove him from the courtroom a very extremely long time ago. That and like Jackson actually getting up there and trying to say that Karen shoulders no blame for the harassment when literally last night both Karen and her attorneys like admit to like working with him for this.
Yeah, and they just everybody acts like, well, that's his source of information. Do you not understand that that's illegal? Like, do you not get that like she's feeding him information to publicize for them to walk into the court to say that this has been publicized? Like, that is fraud in its greatest essence.
But like he just got up there and lied some more after she said she will not tolerate it. So it's like you just did tolerate it.
I mean, like, that's what I was saying. Like, I'm like, she admonishes him, and then up until the point that he's still gonna go ahead and lie to her face right after she admonishes him, and she doesn't even fucking call him out on it.
So
like,
that's
just
what
because the grand jury didn't indict her doesn't mean there's probable cause that they brought it to a grand jury, Jackson.
Well, also for him to sit there and say, that because they voted no true bill, that like magically that means that there's nothing to see here. Everyone on planet Earth knows that that's not true.
Right.
Dude, it just hung up on me. The Zoom just hung up on me. I kid you not. It literally just hung up on me. I was the fifth person to call in. Okay. The fifth person. So I guess, Frank, you're going to have to keep an eye on yours because the Zoom literally just hung up on me. And I was on mute the entire time just waiting. So
what are you waiting for to get into Turtleboys?
Aiden's live. Aiden's arraignment. I just went on mute because this is what I had on my, and this is the music that I was hearing. I was the fifth person in there, so it's like, bro, if I was the fifth person in there and it booted me, chances are it's gonna boot most other people too. Like, this is the music I was hearing.
But has it been promoted that this is a non-public hearing?
No, it's public. What do you mean? It's the Zoom information is from the court. It's public.
That's why. Then how are they booting people? That's what I'm asking.
I don't know. That shit pisses me off. It's because Zoom like gets too filled up and then it automatically, and it's like that's another thing that pisses me off because yes, it's public hearing and I have the right to listen to it, watch it, whatever. Like, and again, yeah.
Well, it's also possible that they cleared the lines just so others can get in. Because it's about.
Yeah, but then you just kicked out people who were in there early to make sure that they got a spot, you know? Because this Zoom is just for that courtroom. It's not for like the entirety of the court.
Freak Aaron Reed said Frank just got dropped too.
Yeah, Frank got it back, he said.
Okay.
He's in again. Yeah, there is something just... I've never seen a judge not call out defense attorneys or even the Commonwealth when they've done some of these things. Usually a judge will literally like stop the court and be like, Mr. or Mrs. So-and-so, you're not going to do X, Y, or Z in my court. And this is your last warning. Like, this is like, that's what I'm used to seeing judges do. I am not used to seeing judges completely ignore what they just did and act like it didn't happen. Maybe get a little frustrated and aggravated and ask a few pointed questions. And then at the same time, sort of like let people know in the way that she's speaking and why what she's saying that like she's not happy with him, but just still not call him out. Still not.
Yeah.
That pisses me off.
Like right after she admonishes him, he just does it again. And she's like, she didn't even say anything. She just accepted it as fact. Like, are you fucking kidding me? I can't with her anymore.
Yeah, it's like, come on, lady.
as much as the Pinks fucking, you know, say she's so crooked and whatever, I'm starting to wonder if she's not actually allowing social media to penetrate her courtroom.
It's a damn good question.
She
Sonny.
is. Whether
Yeah.
she's doing it intentionally or not, she is allowing it.
Yeah. I think Sonny's right too, where like, and I've been saying this since, you know, since the trial last time and before that in 2023, like she's very much ruling by like what she thinks is like going to be appealable or not appealable. And it's like, dude, don't you understand? They're going to appeal no matter what, like no matter what, like no matter what. So you ruling that way isn't going to like change anything. Rule the way that you would anyway, not worrying about an appeal, dude, because I think she very much rules worrying about appeals. Like,
so disgusting. Like this, I mean, look at how many that, like I said, you know, they're going, they've they've appealed all the way up when we all know it's a waste of fucking time. Nobody in their right mind would be like, oh yeah, oh, the jury deliberated, and then you got these jurors that were probably part of a cult in the first place, and this is probably totally false because you have this really bad habit of lying to the court, yet you're bringing all of this as if it's like the whole, I believe, in my opinion, this is all bullshit. I don't believe any fucking thing that any of this defense team put forward about these jurors. I think that they had plants. They probably had people that were turtle riders calling the Commonwealth.
I agree with that.
Saying that shit.
I
Like
think they had quite a few turtle riders in there, and that was half the problem, you know? Like
the whole thing is a bunch of lies. And they're bringing, like, for them to have the balls to bring these lies to the fucking Supreme Court, and like nobody, like, I'm sorry, if I can see this, there has to be people that have way more power than I do that know what the fuck's going on here, and nobody is being like, you don't even have any affidavits from these supposed jurors, and why are you even wasting our time? Like, why are they choosing to even hear these arguments at the Supreme Court level? Like, do you not think that every single defense attorney in every single court case for the rest of time would try to prevent justice like this? Like, oh, yo, after the delivery of the non-verdicts, our jurors are reaching out and saying that they in fact did reach a verdict. So therefore, we should dismiss these charges and not try her again because it's double jeopardy. Like, are you
that
fucking
doesn't
kidding
make
me?
any sense, dude.
I
None at
could
all.
believe a 7th grader in civics class would even entertain that fucking argument, much
No
less the
shit.
Supreme Court.
It agitates me because it's like, dude, this whole thing with the appeal too, like, it is not, they're not going to win. It's very simple. There's no winning happening, okay? None. Zero.
Exactly.
It's just not happening. Like, there is very sound, legal, like, everything to put this exactly where it belongs, which is back down to the court to say, here, there's nothing to see here, like, whatever. Like, it's just fucking obnoxious to me that, like, we even have to, like, talk about, like, oh, well, should we push the trial back? Should we not? Like, that appeal means absolutely nothing. It is a waste of time. It is a waste of the court's time. Like, it's not happening. Like, it's just not freaking happening. Like, she's not going to win that appeal. She's just not. Like,
no, there's no chance in hell. And the other thing that really pisses me off is these pink people and grifters that want to talk about, oh, you guys should be so pissed off. Like, I keep hearing people saying, like, how much is the Commonwealth spending on this persecution? And it's like, you know who you can be pissed off at is you can be pissed off at Alan Jackson, David Unetti, and Karen Reed, because they're the ones that are making the Commonwealth. Like, they're like, oh, why is the defense spending all this money to disprove all this? What do you think? It's called, all they have to do is create reasonable doubt. So Hank is fucking making sure that they're not going to be able to create any reasonable doubt, because if there's any doubt, it's completely unreasonable. That's clear to most of us that have fucking 2 brain cells to rub together.
well, that's the thing, right? Is they're saying, like, oh, there's reasonable doubt. Like, no, you're confusing doubt with something that's reasonable. Okay.
Exactly.
Like, I don't understand what's happening. My frigging StreamYard is not letting, like, I can see, Frank's stream right here for it, but like it's
You're
not pulling it
frozen.
up.
You're frozen. Kick yourself off. Come back in.
All right, let me try that. Let me try that. I'll be right back.
Okay. So I think my biggest but quite possibly the overarching thing that has me so angry and disillusioned is a judge has one job: sit there and make people follow the rules.
Yep.
Don't put your thumb on the scale. It is not the judge's job to preserve shit for appeal. It's the defense's. Make them do their fucking job.
Exactly.
Because right now you're letting the defense walk all over you and you look pathetic.
Oh, I mean, I keep waiting for her to be like, okay, and all these stupid FKR people are like, oh, she's looking for a reason. She's just looking for a reason. It's like, this judge has had so many reasons that are not appealable. She could kick Alan Jackson right out of the state. They could go to trial April 1st, and no Supreme Court would ever overrule that because this guy lied to the court and completely misrepresented facts to the jury, where guess what? If that shit would have went through and she would have been acquitted, that would have been the greatest miscarriage of justice in the history of justice because of what he did. And we couldn't try her again. We don't get double jeopardy. And by we, I mean the Commonwealth, even though I don't live there, but I pretend like I do right now. But they don't have double jeopardy protection for people. But if the prosecution did something like that, oh my God, it'd be the end of the world.
We just got their exhibit, so.
Okay, so Elise has to re-add herself.
Sorry. If the prosecution did that, you're right. It would be the end of the world.
Yeah, it's just, oh my God. My back hurts so bad right now. I'm so tense when I watch this shit. I can't even sleep.
It's just insane to me.
Well, I just got boxes of Happy Mail. I just got 6 boxes of Happy Mail.
Ooh.
What's in your Happy Mail?
Happy Mail is mail sent to me by other people.
Nice.
I never get Happy Mail, ever.
I don't either. I get bills. They're
Right?
multiplying.
Exactly. Bills is about it. But I do want to read this real quick because I did get my very first donation of the stream. Yay! I got a $20 donation, and I appreciate it. I'm not going to read the name because I don't read people's governments, but I appreciate you. Thank you so much. I don't see a question or comment. Sometimes they have them, sometimes they don't. But lately, PayPal's been weird. Usually it pops right up like in the email, but lately it has been popping up in the email, and I've had to actually like go to it and look, but I don't know.
Oh, I'm so like, what does Judge Bev want? I mean, Hank has literally handed her so much evidence on a silver platter. Like, I don't understand. I'm watching him. First time I saw him, I went on, it was the one time I was on Kevin's show on that Members Live, and I was like, this guy he is going to bring justice for John. Like, I was so pumped. And then I'm sitting here watching him deliver it right before my eyes. I get truth chills thinking about him. And then he's doing it. And I'm like, all right. And then I'm like so stoked to see the court. And I'm like, oh my God. Like, she is stonewalling him.
Yeah. Yep. I mean,
being called an enabler to your face as a judge and
Yeah.
saying nothing is fucking humiliating.
Well, that's the other thing. Like, she doesn't even bother, and Hank kind of did call her out a little. Like, dude, listen, you can't keep allowing this to fucking happen in your courtroom, lady. Like, you can't. Like, you got to do something.
Yeah. Like, could you please fucking pretend like you're a kindergarten teacher at least and take some action?
anything, like literally something, anything. Like we are.
And I am
still
sorry, Ange. I
waiting.
stepped on you. What were you saying?
I didn't say anything.
Oh, I thought I heard you starting to say something. My headphones always delay me, and I end up talking over people, and I feel like such an ass.
It happens. We all do it by accident, when multiple people are trying to talk. I just checked and it's still elevator music. So I have it muted right now, but it's still elevator music. We are still waiting for the sewer turtle hearing to happen.
So is that what Hank was talking about when he was referencing the other hearing today?
I think so. I mean, this is the only other hearing I know about. So you would think.
Is Hank going in there with Mel or with Cosgrove? Is it Cosgrove or Mel?
Cosgrove, yeah, I don't know. I don't know how the hell that's gonna work. I'm just assuming that.
Or is he just meaning we as in the Commonwealth is represented there?
Maybe me. I don't know. That's a good question. Maybe we as in the Commonwealth? I'm not sure. Oh, wait, let's see. Hold on. I'm going to check here and see.
The royal we.
Hold on.
Speaking of that, too, the other guy that was there that did the arguments in front of the Supreme Court, I was surprised he didn't push back a little bit further on, like, yeah, this isn't going to go anywhere. Like, they've already been denied appeals like 3 times. So now they're appealing the appeal of the appeal of the appeal. I don't think that they're going to overturn that shit. And
they're not. They're not.
It just makes me wonder more with, like, even with Sewer Turtle, I'm questioning if he's got judges in his pockets, and I'm questioning if, I mean, the outright blatant arrogance of the defense team still now after like I'm like, why are they so convinced that she is never going to go to prison?
I don't know, because it's like you guys live in La La Land. They said, don't you remember? And even in the thing last night, they were convinced that they were not going to get a hung jury. They were convinced that like this was going to be not guilty quick, like right away. And like clearly that is not the way they played out. So you have to remember the way that these people think clearly shows that like they are not in touch with what normal people watch and think. It's not reality. Like they're in their own La La Land. Like,
yeah, I just
sad, but true.
I just hope it's not more than that. Like, I understand they're delusional and they have these delusions of grandeur and all of that, but it really starts to make me worry when I start hearing people just like, yeah, there's no way. She's never going to get. And I'm like, oh, God, if they have judges in their pocket somewhere along these lines. Because I've seen judges, even in Turtleboy's shit, where I'm like, are you kidding me right now? Like, the judge is introducing the excuse of satire for this fuckhead.
That really got me. And I'm like, is this real life? But again, that's part of their judge shopping. That's what they do.
I'm saying.
Yeah. That's part of their judge shopping. Like, it's just really sad. Like,
and how are they allowed to judge shop? Like, why don't they get assigned a judge?
That's what happens. They do get assigned a judge, but what happens is they wait they try to push so what Bradel will do is like, if they give him a judge he doesn't want on a date he doesn't want, he'll just tell them he's on vacation or he can't do that day and it's got to be this week or this week, and knowing that there's going to be a different judge on that week and checking by like, well, this judge was before this judge on the rotation, so the chances of it being this judge or this judge are good. Or they'll wait until they want to file a motion and be heard during one of the judges that they want's rotation.
Why doesn't Massachusetts
judge shopping is illegal? It's not actually legal, but the way that they're doing it, like they need to close the loophole. It's that simple.
But that's what I mean. Why do they not have safeguards for shit like that? It's so obvious that they're doing it.
Oh, it's blatantly obvious the way Bradel does it. He'll literally lie, and that's another problem is why he has BBO complaints. Blatantly lie to the court, like, and be like, well, what did you miss? Oh, I'll tell you what you missed. Hold on, I have to play this. This is for my friend. You missed this, okay?
think we got a super chat. I think we got a super chat.
That's my friend
The
LG's
glare
favorite
who
clip.
makes me
I
wanna
have to
puke.
play it. Yeah, it's. Oh yeah, they are definitely going to waste the money going to the U.S. Supreme Court and get smacked down there as well. Make no mistake, they're going to get smacked down there as well. The U.S. Supreme Court is not even going to take it. Like, it's that simple. Like, it is so clear that, like, it is not double jeopardy. You
Yeah.
do not get a verdict until it is read in. And those jurors can change their minds up until the very moment. Like, them taking a vote, like, that can change. They take 1,000,000 votes. That doesn't make it a verdict. I'm sorry. It doesn't. You know how many times a
Exactly.
vote changes during, like, you know what I mean?
Exactly.
Come on, man. Like, the law's clear.
So frustrating. But that's
It's
what I
so
mean. Like, why
clear.
are there no safeguards for that shit? I mean, I've been in trouble when I was younger. I was in trouble a lot. I can't imagine any of this shit flying in any courtroom. And I wasn't like brought up on charge. I was like drinking violations, minors and DUIs and shit before I got started.
Yeah.
And it's like, I've never been in a court system where this kind of shit would be just like the same thing
Acceptable.
with Jackson today. Like, I'm really pissed at you for lying to my face, Jackson. Oh, well, let me get up here and do it immediately after you just admonished me, Judge. I'm going to do it right now again, right openly in public so all the world can see that I'm lying to your face again. And you're not even going to say anything about it.
Legitimately.
Oh, God, I can't. I want
Like, and that's what pissed me off the most was like, and I think it's what pissed my adopted mama here, Brie, off the most is like, bro, first of all, you know damn well that he's gonna do it again, right? So when you say you're not gonna tolerate it, but then 10 seconds later you tolerate it, it tells him that you're going to continue tolerating it because you did nothing up until this point anyway, and he has done it blatantly over and over and over and over. And even the judge knows this is to rile up his base. This is to rile up the free Karen Reed people by saying a bunch of shit, using keywords to make them talk about the case. Like, that is what he is doing, whether it's relevant to what he's arguing or not. 9 out of 10 times, it's not relevant to what he's arguing, which is what Hank's point was, which is like, he needs to talk about the witnesses and he needs to talk about certain people and invoke Hagen's name because this is for them.
Exactly.
And like, I think he should have been a little more clear though that like, oh wait, I think it might be happening. Hold on.
During this message,
Yep.
please enter your passcode
Oh, we gotta
followed
get
by the
back
pound
in.
sign.
Damn it. He must have got booted again.
There's something known in the insurance industry anyway, as apparent authority, and
Hold on.
what that is
There we go.
someone acting with what appears to be authority just because no one with actual authority stopped them, which leads the public to believe that that person actually has authority. She just gave the defense the apparent authority to lie to the court in Massachusetts.
Oh yeah.
Congratulations.
Yeah, she did. And she basically gave an invitation to any attorney who wanted to in her courtroom to just, continue to frickin' lie. It's cool. It's fine. Just do it because she's never going to do a goddamn thing about it. Thank you, Eva, for your $10 donation. I appreciate you. She said, go get some coffee for Thursday's hearing. Thanks for your time. Thank you, Eva. I appreciate you.
Mason got new toys, and I got the prettiest card that I've ever seen in my life, you guys. Look at the front of that.
Oh, that's pretty.
It's all
I love
cool.
stuff like that. Just a little card when somebody writes like the nicest thing, like that means more to me than like, gold and diamonds, dude. It just does. Like,
Oh,
the little
listen,
things.
this is the sweetest box of love. My grandma passed away 2 months ago, and this is a follow-up gift, and it is the sweetest thing. It has socks and lotion and nails. I mean, it is just the sweetest.
It's a self-care box.
It is a self-care box. I mean, and even included with Mason. So I'm sorry if he finds his new squeaky toys today and you have to hear him a little bit.
That's
I
okay.
just mute it as best as possible. But
Throw chicken, Mama, throw chicken.
Oh my gosh, you ought to see the new toys he got. Now he's got a little boxer and a fox and an otter.
Otters are the cutest dog toys ever. I love otter dog toys.
Otters are just cute in general. What are they doing over at the court? Like, they changed it to 12 o'clock. Like, we're almost at 12:30. Like, you're gonna wait until 1 o'clock until the court goes on effing lunch? Like, I don't understand here. Like, what are they doing?
It's a Karen Reed trial, at least tangentially, right? Somebody's getting a reach around in the back.
Very
Christ,
plausible.
is that true?
It's very plausible.
So they're done over for Karen's thing today?
Yeah, Karen's thing is done, and they're actually not doing tomorrow. They're doing Thursday.
I thought that they were gonna have like all day shit going on.
Yeah, I know, but I feel like this made them not do all day shit because they were supposed to have all day, and they probably could have got through all the motions in limine. And it seems like she only did most of the defense's motions in limine, but she did tell the defense, like, you people need to give me your witness list because the defense's witness list is still not out yet.
These people are such scums, and if I swear to God, if they bring witnesses in, like they brought in frickin' Dr. Doofus and diddly squat Arca fucker faces, like, are you kidding me? If she allows people in like that afterwards again without being on that witness list,
Proper vetting and not being on the witness list, not having reciprocal discovery. Yeah, I mean, that's completely prejudicial to the Commonwealth. It's that simple. And that's what they're going to attempt to do, is try to get things in last minute like they did last time, and the judge should have never allowed it.
I can't. Yeah, and then now, I mean, oh God, her rulings, I can't. She is allowing them to shit on the O'Keefes every single day they're in their courtroom. Like, and all of those witnesses, everybody that cares about John.
Pretty straightforward motions for the Commonwealth that she should have allowed very early on that she didn't. And I was like, what? Like, those are almost always allowed. Like, never mind the fact that, like, what the defense has done was completely prejudicial, period. Okay? To allow Arca to testify at this point is literally just negligent on her behalf.
It is.
It is. I'm sorry. It is.
It's judicial malfeasance is what it is.
Yeah, well, here's the problem with that is in Massachusetts, our judges are not they're not voted in. So there's almost no way to get rid of a bad judge on the bench here in Massachusetts. It has to go through like Beacon Hill, and they have to vote it out of a committee, which almost never happens, okay, because they're too much of cowards to do so, and then the governor has to sign off on it. It never happens. And I literally say never because there's a judge they've been trying to remove in Bristol County, the head of probate, Susan Jacobs. Patricia Haddad, Representative Patricia Haddad, has refiled that for as long as she was in. Every 2 years. It never made it out of committee. There were many reasons that that judge still should be pulled and still is practicing. That is the problem that we have here in Mass. Our judges should be voted in just like anywhere else where they can be voted right the fuck out if they do a bad job. I don't understand it. It doesn't make sense to just appoint these judges and allow them just to continuously do whatever they want. There's almost no consequences for judges that don't follow the law and just do whatever they want in Mass.
Maybe that's why she just doesn't have consequences for lawyers who don't follow the law.
I mean, the BBO, it's hard to get them to do anything, but I think in this case, it's so clear that I think they'd be hard-pressed not to do something when it comes to Jackson, Bradel, Yannetti, all of those attorneys. And Bradel already has numerous BBO complaints. One, specifically, he's still going through for when he was a prosecutor and ignored evidence of somebody else doing it, and that person sat in jail for 30 fucking years. So we already know Bradel's a scumbag who will lie to the court, and I've watched him do it on numerous occasions here, and he already has another open BBO complaint for that, as we heard them talk about in a hearing forever ago. So it's like, how many other BBO complaints does the dude have? And why at this point has he not been disbarred? Because the BBO is very slow, extremely slow. They move very slow. So by the time they even choose to take it on or, you know, investigate it, how many other people has this person done damage to, this attorney done damage to, while you guys waited to do shit about it?
Yeah.
we are not the only ones that are in a holding pattern. I just went and did some checking around the streets, and
Yeah.
anybody that's calling into this is in a holding pattern also. So
God
we are
damn
not
it.
missing anything yet.
Good. Well, you know what? The last time they like completely muted the entire Zoom and nobody heard anything. We had to watch like a video of it like the next day or later that day or whatever. Like, Howard, that's freaking hilarious. But you're right. That's exactly what the cult will be screaming. Literally. This is what they'll be screaming later. Like, you know, that the people in the house put pieces of glass in John's nose in order to frame Karen. Like, that's what they will be saying. That's how insane they are. Like,
Yeah.
because Karen admitted to pulling a piece of glass out of John's, on his nose. Like, it's absolutely nuts. It's insane. Like, it's not normal. Like, yeah, Hank did just definitely get a taste of what Lally had to put up with. I mean, he's known for a while, I think. Hank is very well aware of what he was going to have to deal with. I'm sure Lally, like, gave him the rundown when he first decided to take the case on that, like, hey, by the way, these guys are assholes and they don't care about lying, and this is what they're going to continue to do until the end of time. Like, unfortunately.
That's another part that pisses me off too, because the cult is always, saying that Bev is so biased. And like I said, I've given her so much grace. I am like,
I have to.
I'm like, the woman has to put up with a lot. I just recently, in the last couple of weeks, I'm like, I can't do this anymore. She has culpability in this. She is allowing this to continue. It is so freaking apparent at this point. Like, I know she was probably confused a little bit, but she knew something was hinky in the first trial. But now for Hank to be literally saying, like, look, there's been collusion. Crimes have been committed here. These people should not only be disbarred, they should be arrested. But hey,
They
go
should.
ahead and, just let them continue to represent this criminal because they're criminals themselves. And we'll just call that justice.
Well, what really burned me is she's like, well, Miss Reed wants to continue to have her trial. I don't give a fuck. No offense. What Miss Reed wants. And yes, she has to have a fair trial. I understand that. And she gets the right to her counsel, but she does not get the ultimate right to counsel that's going to lie. That is not an absolute right to have counsel that is corrupt and lying to the court. That is not a fucking thing. So it's like, I don't really give a shit what she wants. Her attorneys probably should have thought about that before they did what they continue to do until this day. Oh, well, Mr. Yannetti can try it himself if he needs to.
Exactly. And no Supreme Court would ever overrule that because she has every right to do that at this point.
She had
There
every
would be
right and every
zero
reason, and
chance of
then
appeal.
some. Because you have to remember, if you appeal, right, like that means they get to look at the entirety of it. Like every little fucking lie and misrepresentation you made is going to, like the first one, not the first one, but the first big one, okay, was when they said the feds will not allow this to go to trial in good conscience. And then the feds had to make a statement that day saying like, yeah, nobody said that. We don't, like, the defense lied. Like, so it's like that right there should have been a sanction, period.
Exactly. I mean, has she even given them any financial sanctions? Anything?
Nothing. Literally nothing.
Oh my God.
That's very true, freak. Fraud wants to know, Sonny, if you can talk more about your thoughts on RICO violations, read the defense.
RICO violations, read the defense. I just think that, again, they have been so blatantly, fraudulently, here's what I think, and Fraud, I don't know if Fraud knows that I have a channel because I talk about this a lot on my channel.
Maybe that's why they're asking, yeah.
Okay, because I just like, so and this is the part that just baffles my mind because A, I'm not a lawyer. B, I have no, like, I'm not like, I'm a true crime junkie and I know a lot of stuff and I pay attention to a lot of stuff, but I don't have a fraction of the knowledge you have on just the law, period, much less Massachusetts law. But I mean, this is literally, as I'm watching this unfold, because when I even came over to YouTube to look at true crime, it took me a long, like, the case that I was looking at wasn't this case. It was the Idaho case. And so I mean, I was already like fully aware. It didn't take me long to figure out that these creators are like completely fraudulently lying to their supporters, which is disgusting. But then
It's gross.
when I got kind of like, that's kind of why I wasn't interested in this case at all, but I wasn't getting any information with Idaho. So I was like begrudgingly started watching this trial, and then I got sucked in because of the psychology of it and watching the ridiculous fraud on the court. Like, what is happening? And then seeing these creators and all the money that's been funneled through.
And that's the thing, right? Have you ever watched one of their streams, right? Like, it's like donation after donation after donation after donation. I mean, I thought she was innocent in the beginning. Like, I experienced it firsthand. Like, people are willing to pay to hear what you have to say. And at that point, I do know the law. So I'm like, okay, I'm giving valuable like insight into like allowing people to understand like how a trial works or how the law works. Like, but when I figured out she was guilty and she couldn't possibly be innocent, like that's where like decisions had to be made. And I wasn't willing to sit there and continue to lie for those donations. And believe you when I say I desperately need them. Like that is income that I desperately need, especially now with my child being sick and in the hospital and with the bone marrow transplant and all that. Like, I need that money desperately, but I'm not willing to sit there and lie for it. Like, I'm just not. Like, I'm going to tell the truth, whether it's the popular opinion or it's not the popular opinion. I don't care. Like, it's going to be what like evidence shows the truth. Like that's what you're going to get from me, period. No ifs, ands, or buts about it. Like,
right is right, wrong is wrong. And we
That's
always
right.
stand up for what is right.
Like, I could be on here 6 hours and not even make $50. Like, you gotta think about it. That's not even $10 an hour, right?
Yeah.
But it's the truth. Like, so for me, it's more like, I don't want this to happen to anyone ever again. The amount of harassment that I have personally had to deal with, like no one, and it's every day till this day, like emails, text messages, DMs, you name it. It's there every day. No one should ever have to deal with that ever again. And if it takes me telling the world 1,000,000 times over, then that's what I'm going to do.
Yeah. And that's why you're invaluable to the community, because there are, I mean, I started my channel because of, I just, the injustice of all of this and the other part that gets me is the people that, because the whole psychology of it, I'm like, these people can't really believe this shit. Like, they can't intellectually be honestly believing this. I'm like, this person is obviously intelligent. So I'm still go back and forth in my own mind of like, do these people?
I do that too. I'm like, how can this intelligent person who is clearly semi-intelligent still believe this with all the evidence that proves that's completely wrong? Also, I have to pee, so you guys have to hold it down for a second.
Okay. But then the other part of that is like the innocent people that the creators are bamboozling, and the amount of money that they're making off of these people
that
they're
happens.
asking for money for.
Happens out here, left, right, and center. That's the whole point of this platform. If YouTube makes money, YouTube makes money.
Yeah, no, I get that, but why do people want to be lied to? That's the psychology of it that I don't understand. Like, why do you want to be lied to? Why do you not want the truth? Like, I'm a true crime junkie, and these people that are claiming to be supportive are also claim to really care about the justice system, when clearly they don't. They care about their narrative. They care about what they want to care about.
The Sebastian Rogers case at all? Have you seen what these people have done for over a year out here on this platform?
Oh yeah, I don't even want to get into other cases because it's happening with all of them. But yeah, I mean,
But it's the same thing. It's the same thing everywhere. It doesn't matter what case it is. There's always a divide. There's always an us versus them.
Yeah, but I think like with most other cases, like with like for example the Idaho 4 and Sebastian Rogers, those are two that I've been paying close attention to. With most other of those cases, I think the people that legitimately support the people that they support, like I think that I think all of the people, with a few exceptions maybe, are being intellectually honest about it. I don't think there's a lot of actual people.
No, that is incorrect. That is incorrect. They are not being intellectually honest on this. That is so far. I have sat for over a year now. I have been out here on these streets since 2012, and I have seen it go from bad to worse to absolutely disgusting.
Yeah, I mean, I don't know. I don't see people like, I don't see other creators being like Turtleboy and Melanie Little and the Glare, where they know that somebody is actually factually guilty, but they
Do
are
you want me
sitting.
to list them off? Do you want me to list the people off? That they are not going after anybody that's factually guilty. They're going after innocent people and making them guilty. Do you want me to list the number of creators? I can think of 13 off the top of my head.
Well, are you talking about people that think that the Proudfoots are guilty?
Yes.
Well, I got to be honest. I am not going to come out here and say that they're guilty, but I think as a person that is a pretty good judge of character, there's not a lot that makes sense with their story. So that's what I mean. Like nobody has proof one way or the other. Where in this case,
Right,
we've
because
already
law
had a
enforcement has
trial.
come out and said from jump that there is no signs
Well,
of foul
see,
play.
now hold on. Like, I don't want to get into this whole controversy again here because I don't want to argue about another case because that's everything with that case. We don't have court documents. We don't have facts and evidence. So that's what I'm saying about being intellectually honest. In this case, Turtleboy knows that Karen is guilty. Melanie Little knows that Karen is guilty. The Glare knows that Karen is guilty. Like, these people are literally lying to their supporters' faces. Where in those cases, yeah, it's all speculation. There hasn't been a court date. There are no facts and evidence. There are no court
Right, but there are
documents.
people that are lying to their subscribers, but there are people that are currently out here lying to their subscribers, saying that they're guilty when law enforcement has come out and said there is no signs of foul play.
Yeah, I get that, but the other part of that is the same thing with Karen Reed. The people that want to simp for Karen Reed are saying, we don't believe that the federal investigation is over because the DOJ didn't come out and say it. Well, guess what? The DOJ isn't going to come out and say it. They don't operate that way. The police officers that are in Sebastian Rogers' case, they're going to say there are no signs of foul play because they haven't found any evidence. That doesn't mean there is no sign. The absence of evidence in that case is the evidence, in my very strong opinion.
Right, we have it, but I implore you guys that it's not a channel that we, really love or support, but that's the one that has it currently.
The trial? Or
Aiden's arraignment.
Oh yeah, I'm fine with that.
Hey, at least I'm gonna have to drop down. I can't do today. I'm sorry. I'm overwhelmed and I'm just gonna have to drop. We'll talk to you later, love. Bye.
All right, bye.
I knew that was gonna happen. That's why I kept begging her not to keep bringing it up. I literally
People are going to have different opinions on different cases. I mean, it's normal to have different opinions on different cases. I don't.
Yeah, but I mean,
one way or another.
I literally said I don't even want to get into this because I'm not here to talk about that case, and I disagree with you. So I think it's best we don't. But she kept pushing it, so I'm sorry if she's pissed at me for saying that. But like,
it happens. People disagree. It's not a big deal,
Yeah, I think it's apples and oranges though. Like, it's a totally different situation when people have facts and they factually know that somebody's guilty and they're still coming out here and doing the shit that they're doing in this.
I followed that case a little, but not enough to. I know there's no court documents though, so we don't really have much other than what people, like what the family and what like both sides of the family have said. That's it.
Yeah, and everything is speculation. The fact that what I think is total speculation. There are no facts, but I have.
Here we go. Oh, they filed a motion to revoke his bail.
Can they hear us or can we talk?
No, they can hear us, so we don't want to talk over it.
Do you hear what's happening? Because I don't.
Yeah, hold on. Can you guys hear it now?
I can't.
Can you guys hear it now?
I still can't.
What the hell? Oh, hold on. Hold on. I'll back it up. Can you hear it now? Can you guys hear it now?
I still don't.
What the hell? No, it's unmuted now on the video. And I can hear it. Weird. I don't understand.
Can your audience hear?
No. They're saying no. I don't understand. I'll try to go out and come back in. Hold on. Hold on.
Every time someone's voice gets picked up on the street, and there's no warnings about it whatsoever. So
Still
Mr.
no?
Carney doesn't have to, when he's clowning around.
Got it.
You got it?
And incidentally, Judge, the last time we were all together in Superior Court, Mr. Carney agreed under Section 87
I'll back it up
to a
after.
stay-away order on this situation. So that speaks well of his understanding that he's not going to risk any other problems or issues. So that's on the side, if I may, Your Honor, that this has been agreed to when the government brought the bail request that they told me they were going to be renewing here. We agreed to it. So I want the court to be aware of that as well. But in terms of this speech, Your Honor, the only reason that the complainant heard this speech is because he was illegally wiretapping Mr. Carney. This never would have come to light. He never intended it to come to light. He didn't know it was going to come to light. And the next thing you know, he's being wiretapped by the complainant, who now wants to use his illegal behavior to try to get Mr. Carney locked up.
No,
the whole
please.
thing is a complete absurdity, Your Honor.
You're
Mr. Carney is talking for the benefit of his friends to a window on a almost empty street at 10:30 at night. There's no danger whatsoever. There's no basis to plug that conduct into the many elements of witness intimidation to try to concoct some bizarre alchemy, some felonious charge that would somehow get past the First Amendment for all the reasons that I
They're asking to revoke
stated
his
in my
bail.
motion, Your Honor. So that's what I have for the court. I appreciate you reading my motion, and I'm asking for about the 10th or 11th time that the court dismiss these charges. Thank you.
No.
Ridiculous.
Thank you, Your Honor.
Cosgrove.
Mr. Albert, as is his son, is a witness in the Karen Reed case. Mr. Kearney has been in the process of conducting a campaign against virtually every Commonwealth witness in the Karen Reed case, using his various media outlets. What I would like to do is briefly read the court some excerpts so I can put them on record from the police report of Lieutenant Tully. Some of it characterizes the video that Your Honor has already viewed, but it's also illuminative of the reaction of the Alberts upon viewing that video. After I do that, Your Honor, I will proceed to address the contentions that have just been raised by Mr. Bradle. Lieutenant Tully indicates that on March 5th, he spoke with Chris Albert, and he mentions that the Reed defense attorneys have alleged a massive conspiracy to frame Reed and have stated in written pleadings in an open court that Colin Albert, who is Chris Albert's son, is responsible for the death of John O'Keefe and that Chris Albert has aided in the conspiracy. Beginning in April of 2023, Kearney began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on civilian witnesses, members of their family, and their friends. He authors and publishes a blog on the website Turtleboy Daily News. The website has a series of articles entitled Canton Cover-Up. He goes on to describe arresting Mr. Kearney on charges he was later indicted with. Those indictments are still pending in Norfolk Superior Court. Chris and Colin Albert are named victims in those open cases. Chris Albert forwarded to Lieutenant Tully 2 videos from March 4th of 2025. Subsequent to that, Your Honor, the district attorney's office merged those 2 videos. So the video that you saw shows the 2 of them playing simultaneously. They're 2 different cameras showing the same events. The sound has also been enhanced, but otherwise the videos are in no way changed. As described by Lieutenant Tully, the video depicts Kearney walking down the sidewalk from the direction of C.F. McCarthy's, which is a bar/restaurant located next to D&E Pizza at 614 Washington Street in Canton. The group is seen leaving McCarthy's that joins Kearney. Kearney stops in front of D&E and places his face next to the glass window. Interior camera catches him standing close to the glass, staring at the camera for approximately 25 seconds. Male with the group that exited joins Kearney. Kearney then begins speaking into the interior camera for over 1 minute. Audio is captured by an exterior camera. The sound of the occasional passing motor vehicle obscures the audio. Lieutenant Tully stated that he could discern the following statements made by Mr. Kearney. "Hi, Chris. What have you done?" "Murdered," then goes inaudible. "Misses you. Wishes he was alive today. He would be." "Why did you do that, Chris?" "Chris, why did you tell the jury that you got home?" "Why did you say you went upstairs and then waited 15 minutes?" "And Colin came home. Colin didn't make it home until at least 12:45. Chris, it was Colin, Chris. I just want to know. I just want to know why Colin took so long to get to your house. Why, Chris? Please tell me why. Colin did it. You can tell me. You can tell me, Chris. I know you didn't do it. I don't want to scare you. Tell Jill to keep their hands to herself, too." The statements made by Kearney in his conduct of standing outside D&E Pizza is similar to the conduct that was the basis for his prior indictments. Kearney directed his statements into a camera that he knew would at least be seen by Chris Albert, a named victim in the pending witness intimidation case and a witness in Commonwealth versus Reed. When Chris saw the video shortly after the incident, he became upset. He stated he is upset for his son Colin and the possibility that Kearney would continue to come to the restaurant and confront him or his son, which I would add, as he has done in the past. Subsequent to that, and as Mr. Bradel indicated, I brought this conduct to the attention of the Superior Court at a hearing on Mr. Bradel's motion to dismiss about 2 weeks ago. Lieutenant Tully received another video, and I want to add, with respect to the first one, that what brought this Chris Albert's attention was that on March 4th, he received a phone call from his son Colin, who was working at a pizza restaurant that he owned. Colin learned that Kearney was having dinner at the restaurant next door. He was very unnerved and anxious about Kearney being next door while Colin was working. Chris, who was attending a Canton Select Board meeting, traveled to D&E following the meeting, and they closed the pizza restaurant at 9:30 and went home. He then received an alert on his cell phone from the camera system at D&E Pizza, accessed the video recordings, which Your Honor has viewed. Chris was very upset about Kearney's statements into the video camera, especially given previous incidents where Kearney picketed outside the restaurant during business hours. He's also very concerned Kearney will continue to be outside the restaurant and will confront him, members of his family, or patrons in a similar manner Kearney has done in the past. And I think the second video that Your Honor saw was a later discovered video indicating that Mr. Kearney had been present earlier in the evening. Now, with respect to the motion to dismiss, if I can turn to that in this point. I don't have a quarrel generally with the proposition the First Amendment protects a wide range of free speech. and that the usual remedy for a victim of defamation is on the civil side of things and not on the criminal side. But what the defendant ignores, and I believe Mr. Bradel ignores, is the courts from the U.S. Supreme Court on down have said, where the Commonwealth or the state has a compelling interest, it can craft an appropriate limited criminal sanction regulating speech in a reasonable fashion as to time, place, and manner. Now, there are a number of examples of that in our law, Your Honor. I'm sure Your Honor has probably had occasion to issue 209A orders. A typical feature of those orders is that the 209A recipient is to have no contact, direct or indirect, with the victim. In the cases have uniformly supported that when that contact is made, whether it's a phone call, we might otherwise say is freedom of speech, even if it's an innocuous subject matter, even if the defendant sends the recipient of the 209A order, the protected person in the 209A order, a bouquet of flowers, that is a violation that may be criminally punished. We also know that laws protecting courthouses and prohibiting disruptions outside of courthouses are also constitutional and legal. We also know that judges routinely impose conditions of probation requiring no contact, stay away, not travel in a certain area. Those orders, too, Your Honor, arguably impinge on rights of free association and speech, yet all of those are constitutional and have been upheld. With respect to the victim witness intimidation statute, which is at issue here, the legislature has imposed a very limited restriction on speech. And the limitation comes in the form of two elements. One is the protected class is not the public generally. They are left to their civil remedy. But the protected class are witnesses in a criminal case. The second reasonable limitation, the second restriction, Your Honor, is that to prove witness intimidation, the Commonwealth must prove beyond a reasonable doubt the specific intent of the defendant's conduct was to intimidate the witness. Now, it seems to me, Your Honor, that one of two things has to be true. Either 209A orders, probation conditions, and laws against disrupting court proceedings are unconstitutional under the First Amendment, possibly other amendments as well, as is the witness intimidation statute. Or the witness intimidation statute constitutes a reasonable limitation by the legislature in service of a compelling state interest, which is the integrity of the criminal justice system. Mr. Kearney has effectively conducted a campaign against virtually every Commonwealth witness in this case. It has been unrelenting. I don't know if I am to go back to those witnesses, those victims, and say, well, you have a civil remedy, go over to civil court, file a lawsuit, hire an attorney if you can find one, retain him for $1,000 or $20,000 or $50,000, or maybe you can get a contingency fee. And then after depositions and motions and interrogatories and so forth, 3 or 4 years from now, you might recover a nice civil judgment. But in the meantime, every day you are going to be hammered and intimidated, and there is nothing the criminal justice system can do about it. Those seem to me, Your Honor, to be the alternatives. And based on that, Your Honor, I would ask you to deny the motion to dismiss.
I have a couple of
Briefly.
Judge, page 5 of my brief, U.S. v. Alvarez, sets out the entire field of where the government can intrude on the First Amendment. There's no provision for reasonable restrictions on this or that. There's no opportunity for the Commonwealth of Massachusetts to try to criminalize civil tort law somehow.
I don't think that's what Attorney Cosgrove was saying. I think what he was saying is that it's a different class than the general public. And while I agree with your sentiments regarding Alvarez and the general public, what we're talking about is a more restricted class, specifically witnesses in a criminal proceeding or possible witnesses in a criminal proceeding, and in this case, a known witness in a criminal proceeding.
There's one other issue there, though, which is that there's no stay away order. It's not even a stay away order.
And that's
the determining factor.
well, that may be the determining factor.
There is now.
At the end of the day, with respect to a defense at trial, or perhaps whether or not his conduct was harassing as the statute anticipates. But the standard of proof that I need to apply here is whether or not there's probable cause that he's violated the statute. And the statute that reads that did mislead, intimidate, or harass another person who was a witness or potential witness.
Yes.
And
Can I address that point?
Sure.
Thank you. I appreciate you letting me jump in. Harassment is defined, and harassment is limited by O'Brien v. Borowski, true threats, fighting words. So manifestly, these videos have no threats, no fighting words.
Wait, so take the sound out of
Not
it.
just that.
The video that I watched that you both submitted by agreement
That's threats.
begins with him just staring directly in the camera. He's not passing by. He
Body
walks
language.
to the camera
That's a
and then he
threat.
walks back in the direction from whence he came. And he's staring at the camera for a prolonged period of time before another individual comes up and starts speaking to him, and that's when the words happen. And whether or not you have a Fifth Amendment claim for the witness at trial because of wiretapping or not, it's not what's before me. What's before me is whether or not there's probable cause to support the charge. And after considering your motion and the depths of research you've done on the First Amendment, and considering the standard of proof that I need to apply here, which is probable cause, I'm going to deny the motion to dismiss.
Thank you. As he should.
Your objection certainly noted.
That is awesome.
Well, I knew that he wasn't going to get anything dismissed. That's not going to happen. There is probably.
That is fucking awesome.
Now let's move on to the bail revocation. Revoke it, Your Honor. Exactly, freak. You are on the same wavelength there. Revoke his fucking bail.
What a dip schnitzel.
Commonwealth, I hear you on your motion and any request for bail.
Yes.
Can they hear us, please?
They can, yeah.
Your Honor.
My audience can. The court can't.
Oh, that's what I meant, the court.
With request to bail on this case, Your Honor.
Does Mr. Carney be arraigned first?
He was arraigned. Right? You entered pleas of not guilty. He was arraigned. I mean, I would have stricken the arraignment had I allowed the motion to dismiss. That's why I wanted to address it first.
Yep.
With respect to the question of bail, Your Honor,
revoke.
I'm going to request that the court set bail in the amount of $5,000 cash.
Revoke. What the?
In the instant case, and I'm going to ask the court to impose a stay-away order
They already have one from the other court. The fuck?
from Mr. Albert.
Oh my God.
And any member of his family.
That's not stopping him. Time to revoke.
And I'm going to ask that
What the hell?
that order, I should say a no contact order, direct or indirect. And I'm going to ask as well that the court order that Mr. Kearney remain away from the pizza shop.
Come on, man. You already have that from another court. Why are we asking for the same thing from another court?
And from any place of work, the Alberts, and that he maintain a distance of at least 100 yards from those locations. The order in the Superior Court, I will say, is a little broader. The order entered the other day, and it now extends to all of the witnesses in this case. But since only the Alberts are implicated in the case before Your Honor, I think it's proper to limit the order here to them.
Why are you asking?
How about the judge just revokes it anyway?
Yes. With respect to the motion to revoke, Your Honor, I think it's important to consider that this is the same conduct, or another species of the same conduct.
Yep.
For which indictments are pending against the defendant in the Superior Court. There are indictments for intimidation of a witness with respect to Brian Albert, with respect to Christopher Albert, and with respect to Colin Albert. These indictments represent a series of conduct by Mr. Kearney, including showing up at selectmen's meetings where Chris Albert is a selectman. In one meeting, Chris Albert testified before the grand jury that at that meeting, Mr. Kearney came within 2 feet of his ear, holding negative signs about him, stuck his middle finger in his face, captured on camera for his viewers. And as he left the building, he and a mob of about 15 or 20 people pursued him to his car, screaming at him, calling him and his son a murderer. When Chris reached his car, Kearney and his followers surrounded it and prevented him from leaving until the police were able to back up the crowd. He's encouraged people to harass Mr. Albert at his business. He's run videos attacking members of the Albert family, including Mr. Albert's wife. I'll read you some of the titles of those, Your Honor, that were played for the grand jury. Episode 590, Call to Julie Albert. Julie Albert, I might add, has nothing to do with the Reed case, but in Mr. Kearney's view, she's a fair target because she's related to somebody who is. Therefore, to attack her is another way of putting pressure on and intimidating a witness. Episode 598, Life as Normal is Over. Time to hit the gas. No right for Chris Albert to live peacefully. Albert should be afraid. Kearney outside D&E Pizza. And those, Your Honor, were examples of some of Mr. Kearney's shows prior to the indictment.
Lock him up is right.
Indictment has not fazed him, Your Honor. He's continued to harass the Alberts and the other witnesses.
And everyone else on planet Earth.
When you look at the videos in this case, if you looked at them in isolation, if I looked at them in isolation as a prosecutor, I might think, oh, well, there may be a few sheets to the wind after his visit next door. He's clowning around. It's fairly innocuous, repulsive, but innocuous. But understandably, the Alberts and the Commonwealth look at them in the context of the prior conduct. His conduct has continued since his indictment, not only with respect to the Alberts, but as to the other witnesses. If Your Honor has viewed the exhibit submitted by Mr. Bradel, I had some discussion with him about what I would be asking for today. And I didn't indicate, quite candidly, that I was going to move to revoke Mr. Kearney's bail. That was not my original intention. But I did say subject to, I don't recall the exact language, but Your Honor has it in front of him, subject to what may go on between now and then. Shortly thereafter, I discovered that Mr. Kearney had gone on one of his YouTube presentations and encouraged every resident of the town of Canton to file illegal wiretapping complaints against Mr. Albert. Now, I'd be the last person to say complaints that citizens should not contact police departments if they think there's been a violation of the law. But one of Mr. Kearney's attorneys, Mr. Betterow, had already sent a letter, which I suggest was retaliatory in intent, to the Canton Police Department, claiming that Mr. Kearney was illegally wiretapped. Well, the Canton Police can do with that whatever the Canton Police are going to do with that. I think it would be improper for me as a person charged with prosecuting, as a special prosecutor charged with Mr. Kearney, to even express an opinion to the Canton Police Department. I have my own opinion of the merits of the complaint filed by Mr. Betterow. But that having been filed, Your Honor, what possible purpose does it serve for Mr. Kearney to encourage every citizen of the town of Canton to go and file complaints? And I suggest it serves no purpose but to harass Mr. Albert. I would also suggest that it's difficult to look at that video and think anything but that Mr. Kearney clearly saw the video camera, which was visible in the window, and wanted that video recording to be seen and, if possible, heard by Mr. Albert. I think one of the things that may be concluded by the Canton Police, and I don't want to get too far out in front of my skis, is that the illegal wiretapping statute requires that there be secretive video. And when a video camera is clearly visible in front of a store, I would suggest that's not secretive and therefore it's not illegal wiretapping. But if it is, I think when the Canton Police act against Mr. Albert, they can then do a survey of the whole town and possibly bring charges against everyone who has one of those doorbell videos. That said, Your Honor, it was still not my intention to move to revoke Mr. Kearney's bail. But then I became aware just a day or two ago, and I only became aware of this yesterday afternoon, Your Honor. Mr. Kearney, on his show, engaged in about a 10 or 15 minute vile attack on Elizabeth Proctor, describing graphically her giving oral sex to her husband and other such comments. Elizabeth Proctor has nothing to do with the Karen Reed case, except that she is the wife of a police officer involved in the investigation and a witness in the case, and therefore fair game for Mr. Kearney.
Ugh.
And I mention this in particular, Your Honor, because one of the things that I understand the Commonwealth needs to show is that no order entered by the court is likely to be effective in eliminating the threat to the public, or in this case, the threat to witnesses in the Karen Reed case and in the Kearney case. And I would suggest the threat to the fair and objective administration of justice. I think that Mr. Kearney, by his conduct, has amply proved the court he is going to keep going with his intimidating conduct.
Yep.
As long as he is free.
Yes, yes, he is.
And therefore, I ask the court to revoke his bail.
Attorney Braden.
Your Honor. Your Honor, Commonwealth uses the word retaliatory.
Yeah.
This entire bait and switch
Oh, please.
the Commonwealth has perpetrated on me and Mr. Kearney is the only thing that's retaliatory here.
Oh, please.
He's such a dope.
Friday, counsel emailed me with respect to the bail issue here today. I said to him that
whining.
I had, at the time, 2 other cases today.
That isn't going to help
I
him.
actually have 3 other cases today. But I don't have time on that date, meaning today, to do what we've been doing here for however long. That if we're going to have a quick bail hearing where the issue is how much money and stay away orders that we've already agreed to in front of Judge Doolin in Superior Court, I could have, that's what I expected today. And I've never, in 32 years practicing law, had a prosecutor or seen another prosecutor when I was a prosecutor say to me, yeah, come on in, we'll get this done quick, everything's going to be fine, and then come into court 5 minutes before
Change his
coming
mind.
before
Oh,
Your
wow.
Honor and say,
You're
no,
not
we're going to
the
revoke
defendant.
his bail. Oh, really? Why? Because he said something nasty about somebody. And here's the kicker, Your Honor. In
No,
a
'cause it's
private
private.
show that people have to pay to hear, not in
No.
public, to a private.
It's a fucking lie.
It is public.
That
That's a fucking
somehow
lie.
got leaked out to whomever.
No.
And that show was Thursday night before the Commonwealth committed to a normal bail hearing where
It's
there was
open
a
to the
very
public.
minimal
I have the
issue at stake.
transcripts.
Now the Commonwealth wants to come in here on 5 minutes notice to me.
Doesn't matter.
Change it
They can
up
do that. They
because
have
of
that
this.
right. Stop whining.
Pretextual
Yeah, and guess what? If
views
he makes those
about
cases,
something he said that is non-criminal, non-actionable, that he doesn't like in a private setting.
Just move full rampant.
That's what's retaliatory, Your Honor.
No,
Well,
please.
perhaps I can short circuit all of this.
Please do. Thank you.
Wasn't this addressed in front of the Superior Court? This conduct was addressed?
It was, Your Honor.
So I think under my reading of the bail statute, Mass General Laws, Chapter 276, Section 58B, that the motion to revoke has to be brought at the first appearance in court. It doesn't say which court, it's first appearance in court. If he got
No,
arrested
supposed
in
to be
Chelsea,
arraigned.
this hearing would be happening in Chelsea at the moment of his arrest. And so the idea that this was addressed in front of the court who's hearing the case on which the Commonwealth seeks to revoke,
Yeah, you
and there were
preempted that,
conditions
fucking dumbass.
placed
They don't
as
have to.
opposed to bail being revoked at that point in time, I think was the first appearance. And I'm procedurally denying the motion to revoke bail because I don't think it's properly before this court.
Thank you, Your Honor. In that case, we would agree under Section 87, Your Honor.
oh
Come
my
on, dude.
What about the cash bail request?
In Judge, in terms of a cash bail, Mr. Carney's got no record.
I highly
Every
disagree.
court appearance, we talk.
He needs to stop
times a
being
week.
so nice,
He has 2
Cosgrove.
kids, lives in Holden. He's a former
I
school
disagree with the
teacher
judge
who
on his
shows
reading
that he does every single night.
of it having to be the
I
first
don't
court
know of
appearance. It's
anybody
usually
who
the
has more
arraignment.
roots in here that's not
That's
gonna
literally what Cosgrove said. He was going to wait till
So we
arraignment.
ask that you forego a cash bail, Your Honor. And he's
God.
absolutely willing to just make it a Section 87 agreed on bail condition relative to stay away orders. And we ask that you allow that, allow him to appear on his personal recognizance.
No. He's got to have some fucking something. It doesn't make sense to put a double order in. No, I disagree with the judge, Freak, because 9 out of 10
So
times
after
it is
hearing on
done
bail,
when you're arraigned.
I'm going to release the defendant on personal recognizance with the following conditions. Stay away, no contact, no abuse of the Alberts, remain 100 yards away from the pizza shop and any other workplace, stay 100 yards away from their residences. That's with the consent of the defendant.
Correct, Your Honor.
You're right, ROC, he will shoot himself in the foot over and over again because that's what he does. But it's like he never gets accountability. Ever. And I disagree with the judge. It does not have to be the first hearing means the first hearing about this issue, as in after you've been arraigned, because his issues were on the other charges. That was in a different court, and he just happened to have a court date. That doesn't constitute the first hearing.
That's fine.
Yep,
Oh,
he
wait.
hasn't been arraigned. He
That
hasn't
one
had a
of the
clerk's
dates that
hearing.
was-
This is the first hearing on this
I
charge.
don't get why they have an old hack like Cosgrove be a special prosecutor.
May 15th, fine.
Because you know what's more
So
fucking
you're going to be
annoying?
released with conditions
That
for your
dude
parents
checks
back
on
here
you,
May
right?
15th for a pretrial hearing. Conditions are that you have no contact directly or indirectly with any of the Alberts and family members, that you remain 100 yards away from the pizza shop and any place of business in the home of the Alberts. Failing to comply with those conditions or picking up any new charges during the pendency of this case, you could be held up to 90 days without bail. That's your bail warning. You'll need to check in with probation. Before you leave the courthouse today, you'll need to sign those conditions of release. Commonwealth's motion to revoke your bail has been denied. The motion to dismiss has been denied. You're all set, sir.
Attorney Bradel, just to be perfectly clear for the record, the defendant consents to these conditions I've checked off under 87 that he's a, okay.
Thank you.
All right, thank you.
Thank you.
No, that's all we have.
Court, all right.
I'm just disgusted. I'm remembering this, but I'm utterly fucking disgusted. I do not agree at all. Not even a little bit when it comes to the judge's reading of the way it's supposed to happen with the bail revocation, because bail revocation is supposed to be, yes, on the first hearing, but of that charge. He just happened to have a court date on his other current charges. That does not constitute, under that statute, the first court date. Like, you can't just happen upon a court date you already had for other charges. Like, this is the first court date for this new charge because it's his arraignment. Like,
Yeah,
I'm
and
really tired of the friggin' judges over at Stoughton, and I really honestly do think that there is someone over there helping him, and I think something shady is going on. Like, I just do.
The fact that Cosgrove literally in that, when he showed up and got those new charges, literally said it wouldn't be right of me to revoke his bail today, so I will give him the opportunity to consult counsel and whatnot. And then this shit, like, but why didn't Cosgrove fight that? Why didn't Cosgrove stand up?
You can't appeal. You can object for the record, but you can't appeal as the Commonwealth.
Well, no, but I mean, if I was Cosgrove, I would have been like, Your Honor, I understand your point. However, when he appeared, I would have just said exactly what you said. And I would have said, when he appeared, I specifically said I was going to grant him time to consult with his attorney on this. And therefore, we were going to discuss bail revocation on his arraignment.
Yep. But that's the thing, right? He called the Commonwealth, and this is a good point, Ellie. corrupt, right? Everyone's corrupt, but they keep giving leniency to him. He keeps shooting himself in the foot and doing shit he knows he shouldn't do, harassing people consistently and constantly. And they don't think it's time to revoke that bail. Like, make no mistake, he will continue doing it. He'll do it again. And at that time, they'll ask for the bail revocation. And it's like, okay, how many times can you ask for bail revocation before somebody's bail does get revoked for this kind of shit at that point? You have 20 charges, felony charges pending. 20 felony charges pending right now, dude. Anyone else would have been locked the fuck up and the key would have been thrown away. You do not get to subvert the law, continue to do whatever the fuck you want until the cows come home, and then nothing happens. But make no mistake, they might have given him leniency today. Make no mistake, he will feel emboldened, because he's a narcissist, by this, okay? And immediately do something fucking stupid. Whether it takes a day, a week, an hour, he will immediately do something fucking dumb. Because that is who he is. He cannot help himself. And he starts to feel like nothing's ever going to happen to him. So he gets worse. He doesn't think things through. He just does them. He's in fight or flight mode, but more like, I need to hide what I have done wrong, because if the people who are paying my bills and sending me donations find out, they're going to realize that I have been lying, and I'm going to lose it all. Make no mistake, the first thing he said, okay? First thing he said to his ex when some of this was like pre like him being arrested and like people finding out that he was cheating on his wife, the first thing he said was, I'm going to lose all my viewers. That's all he cared about. He doesn't care about anybody or anything other than himself. And it's funny because like he'll even attack his own viewers. If there's someone who doesn't constantly donate to him, he will literally attack them if they give any sort of critical anything to him. Like, he freaks out and loses it. Like, fuck you, you go to hell. These are longtime viewers of his, and he's just telling them off because like he might have been wrong about something and looked stupid and they were right. Like, I mean, it's insane. He told people that they can't donate. They have to donate more than $5 or it's not worth it for him. I'm sorry, what? I'm sorry, what? I don't care if it's 50 fucking cents. If somebody is sending you their hard-earned money to help you out because they like your content and they appreciate like whatever you're doing, I'm not going to say work for him because he's never worked for a fucking thing, dude. Like, we actually do work over here, like, you know, to prepare for things. We actually do research. He does none of that, none of it. Everything is fed to him, spoon-fed. And he doesn't even, FYI, he still doesn't even read all of the court documents. To this day, he has still not read every court document in the Karen Reed case. That is disgusting, okay? He finds them boring. The man doesn't understand law if you paid him to understand law, or how a trial works if you paid him to understand it. So, like, for him to say to someone else, like, you got to donate $5 or more if it's not worth it to me. Like, how dare you? Like, I'm sorry, what? I don't give a fuck if it was 25 cents, 50 cents, $1, like whatever they gave, you appreciate and you say thank you, because without them, you're where? Where are you? Like, there's 748 people currently watching my stream. And make no mistake, some of them are hate watching my stream. 749 now, okay? And make no mistake, like I said, some of them are hate watching me. They can hate watch me until the cows come home, dude. I don't care if it's 747 or 47. I have a community here of people that I absolutely adore and love. And I don't give a shit if I make $20 for 8 hours or 800, because I'm still going to come here like I always do to cover these things. Would it help if it wasn't $20 a stream? Yeah, of course it would. Like, every creator should be paid for their work if you do the work. What paid for is smearing people and lying constantly. That you don't get paid for. When you step over the bounds of lying to your audience and saying it's fact, knowing it isn't, that is where it becomes a fucking problem. Okay? Like, it's insane to me. Like, absolute insanity to me that, like, and it's Stoughton, and in itself, it's a district court. So it's like, indict his ass then. Bring it back up to the fucking, you know, SJC Supreme bring it up to the Supreme with the rest of his fucking charges and revoke it then. You know what I mean? Just do it that way then. Like, just indict on that one. Like, call it a fucking day. You don't want you want one witness intimidation charge in the district court? Like,
So stupid.
while you're at it, indict his ass on conspiracy, since Karen just admitted in that interview that that's kind of what they fucking did. Like, without saying it's conspiracy, is exactly what she did. Like,
Yeah, I mean, she gave the definition of conspiracy, but the people over there they're not even smart enough to know that. I swear, FKR, this has to be all of their very first true crime shit that they've ever watched, because they have no, like, they're so easily manipulated and told blatant lies that any person who has any knowledge about the law at all would be like, wait, that doesn't make sense.
so that's the part that pisses me off, Sonny, right? Which is when people, like, especially on X, will like comment under something I wrote and be like, like, you know, or someone dumb writes something like, oh, well, Attorney Bennett would know. First of all, I've never said I was an attorney. Never. Not once, not ever. But I don't have to be an attorney to know more about the law than practicing attorneys. Just to be clear here. Okay. Number one. Number two, when you say that, you're not insulting me. I do know more about the law than you do. Most layman people I know more about the law, and it's simply just truth. So it's like when you say, oh, I'm not Attorney Bennett, like, no, you might not be Attorney Bennett. I could help you understand it though. Like, I could help you be you know what I'm saying, and know just as much as I do. Like, but it's like those digs that they try to take to try to like make it seem like, oh, well, you're not a practicing attorney, so you wouldn't know any better. Like, well, that would be your mistake to make, to think that then.
That's why
my track record proves otherwise.
That's why I find it so particularly egregious, and that's why I try to like call attention to people like Melanie Little and shit, because they are attorneys, and because they have that attorney license, they have so much more responsibility, and that's why I say, like, brings me back to the RICO stuff. Like, they're blatantly lying, and they're knowingly lying, and they're doing it to raise money and to get people conned into giving them money. Meanwhile, there's so many people that watch Melanie Little that think that she's a good person and has so much class and integrity, and like they're taking legal advice based off of, even though she does a disclaimer, this is not legal advice.
Well, it's not. Like, let's make that clear. It's not legal advice, dude. This is me explaining in layman's terms so that people understand better, like how a trial works, what certain things mean. Like, it's not legal advice.
But it's like it's like you're in a law class. Like, I'm learning from you when I watch your show about how the Massachusetts law works. Same thing when they're watching her show. But she is blatantly telling them shit like, the feds haven't come out and said that the investigation is over.
She knows damn well that's not how the feds work, and they're never going to do that.
That's what I'm saying. So, but her 8,000 people watching her think, oh, well, then clearly that's what they expect the feds would do. Like, there's
that's the thing. She also knows damn well too that, like, Brennan saying it in court, it's on the record. Like, the defense was told, like, Melanie Little knows damn fucking well that means that. But if she says that, then all of her people now start to attack her, and they don't donate to her anymore. That's not happening for her anymore. So she will not. She will just feed the monster. And yes, Maestro's right. She is a clueless effing idiot. Let's all remember, she also never practiced criminal law and knows not a single goddamn thing about criminal law in the state of Massachusetts. And she makes that very abundantly clear when she speaks.
Yeah, but that's why I find it so egregious, because so many people, I can tell when they talk to me, leave me comments and shit, they'll make comments and I'm like, okay, Melanie Little, like, I know exactly where you got that from. She's constantly bitching about Hank not attaching affidavits. And I'm like,
he doesn't have to attach an affidavit to everything.
Exactly.
It's the law, bitch.
Exactly. But all of them mimic that now. The people that watch her, and then all of the law to grifters, like the defense diaries and all these other assholes.
Yeah, it's a mantra. They'll repeat the mantra over and over because it makes people believe that it's a truth. That's why. If they say it enough, these people start to believe that's truth. They don't actually go and check and do their own research. They literally just sit there and repeat what someone else said or what they saw typed a million times and assume that it is true. Like, Thank you, Janet, for the $10 donation. She said for Turtleboy's arraignment. I appreciate you. Thank you so much.
And
If
like
anybody
that,
else wants to, the information is on the bottom of the screen. PayPal, Cash App, Venmo, and please make sure you like because we appreciate that over here.
like the Olivia Lambo or whatever the hell her name is.
God.
She's like Melanie's mouthpiece too, and so she's over there saying the same shit she does. She goes on the glare and everybody, yes, they didn't attach affidavits. There's no. I'm like, I'm so sick of hearing that. Do you not understand that if a prosecution puts that shit in writing in a court document and he's fucking lying about
On
that
record.
shit?
Yeah.
Do you understand
That
what
could
would
be a
happen?
mistrial.
Oh my God. Like, come on. But they all believe it. They all are like, Hank's lying. Like, what
Yeah.
do you
I'm
think?
like, dude, to have any brain cells in your head to actually say Hank's lying and actually believe that is
Oh,
the problem that I then have. Okay. Hank can't just lie about that on the record. Also, make no mistake that if the feds didn't close the investigation, which FYI, I will point out once again, I told you guys a year ago was dead, and it was dead then. Like, I already knew. I tried telling people, but no one listened. Also, Ted Daniels knew. He just didn't say anything to y'all.
So disgusting.
There's that, because Ted got the same stuff at the same time I did, so I know damn well for how long Ted has known, and I waited and waited to see if he was ever going to say anything, and he didn't. He said nothing. He sat there, did an interview with Karen, still said nothing. It's amazing to me. Like, it's amazing to me.
Investigative journalism, I swear to God, these people don't know the first thing. It's such a disgrace these days what it's become. There's no investigation.
Nobody investigates anything. Everything is fed to them through Karen. Everything is fed to them through Karen, to Aided, and then to all these other grifters. Now, remember, like, I love when people try to say, like, you guys are the ones grifting. Like, FYI, there's no money in speaking the truth over here. There is no millions of
Exactly.
donations by saying truth. Do you see me reading them every 5 seconds? That's because they're not coming every 5 seconds. Like, you know what I'm saying? Like, that's like, you can only call somebody a grifter if they're grifting off something, number one. Number two, like, it doesn't take someone who's too intelligent to figure out that if someone says something that doesn't sound right, maybe you look into it yourself. And the problem is everything sounds right to them. They're like, oh, that makes sense. That makes perfect sense. Like, perfect sense. I did, Suzanne. Thank you. I saw that. I responded, unless it didn't go through, but I did. Are you talking about on the last video? I do check like daily because I'll get like little things saying someone commented when they're watching the restreams of them, and I appreciate that. I love my replay crew. But I mean, at this point, like the amount of things that Karen alluded to yesterday in that documentary, and that's multiple parts, is gonna screw her royally. Oh, I have a $15 donation from the House of Beaver. Thank you, Anna. I appreciate you. The amount of things that she said in that documentary last night are going to screw her royally, and that's why they were trying to do damage control days ahead of time. And
Can Hank use that in trial? Does he have access to that since it's new?
I mean, obviously he's watching it. He's got to have the original unedited stuff, I think.
That's what I'm saying. I know he can watch it, but he can't bring in. That's why they couldn't bring half the shit in last time, because they couldn't get access to it.
But I do think that some of these little tidbits, like Karen saying that John took her glass, like, okay, now they know that they don't need to match John's glass. They need to match the kind of glass that Karen had.
Yeah, those are helpful things, but I'm just like, for them to try to figure. I mean, I don't know if the scientists are going to go back and try to do that. I mean, are they re-investigating the glass pieces now? Do they even have time to do that?
I mean, he did mention it, so I would assume that, I mean, if they'll make time, they'll make time if that's what they need to do. Because Hank mentioned it today, which means that's something that he's clearly looking into, you know?
Yeah.
So I guess we'll find out, but he did mention it today. I actually want to go back, if you guys are okay with going back and watching the very beginning of what Canoni says to Jackson. I've been arguing with a moron who thinks the First Amendment protects him. Yeah, so you have to remember, DJ, that all of these people listen to the sewer turtle that tells him that the First Amendment protects you from everything. You can say whatever you want and never get in trouble because that's what the First Amendment is. And I will caution people that that is wholly false and that the First Amendment is not absolute. There are limits to that. There's a reason why you can't run into a crowded movie theater and scream fire when there's no fire. Like, okay, there's a reason. It is not absolute, not by a freaking long shot. So anybody listening to him when it comes to that, again, anybody listening to him on anything, I suggest you don't. I suggest you go look yourself. Go actually do research. And I don't mean listening to everybody else who said the exact same thing as you on X. I mean actually going out of social media and doing actual research on like what actual law something applies to, whether something could have happened. This whole Proctor planted the taillight for more than a year. He never even went to 34 Fairview. So how did he plant the taillight? Also, there's video of them getting the taillight up. Like they took a whole video of it and you can see like it's under the snow, not on top like he told you guys before. It wasn't on top of the snow. He lied about that. And also it wasn't sprinkled because then there would have been holes that would have been covered over. So when you blew the snow away, you would still see holes on top of the snow where it was underneath in the middle.
Didn't you know that Proctor is a shapeshifter into a gopher?
I mean, he's a Doctor Who, man. He just got in his, telephone box and was like, "What it do, man?" Like
he's a gopher under the ground from the Sally Port straight over to 34. Like, come on.
But at the same time, like now you have been telling people like, just kidding. Yeah. I've been telling you for a year now, it's not Proctor, but like, I mean, it is, but just kidding. It's not anymore. It's someone else. Like, oh, you just realized that there's no possible way you could have because he wasn't even at 34. So stop it. Like,
but that's what I mean. Like, there's this contingency of people, and it's hard to know who's who because, like, that's why I was saying I go back and forth on these people know she's guilty and don't care. And then there's people that do still believe that she's innocent. And it's like I came to a point a while ago where I kind of stopped talking about the case because it was ruining my mental health. And
yeah, I had to too at one point. I had to too. Like everybody's got to take a break at some point, because the stupidity, right?
And I was like, well,
there's no arguing with stupid people.
Yeah, and at that point, I was convinced that people that were still supporting her knew she was guilty and didn't give a fuck. But then I'm like, wait a minute, these people really sound like they do still believe her. So there's still bamboozled people, but there's many. There's this contingency of people that literally they want her to get away with murder because it's Karen, and I just can't even believe it's Karen. Like that Lauren Conley, like these simps that are like second degree is just. It's overcharged. Like all these talking heads. Like, why? Because she is halfway decent looking and she's a professional. She can't be a murderer. Like,
yeah, some people actually said that with like a straight face. And I was like, what?
Multiple people have said that on interviews, on podcasts, and on like social media. Like, are you like, really?
Like that can't be real life, man. Like it can't. Like
I mean, Ted Bundy was kind of attractive, so like he can't be a murderer either. He certainly can't be a murderer because he's good looking and
not even a little. Like Potluck, thank you, Potluck, for your $10 donation. I appreciate you.
I mean, there's just no way she did this shit on purpose. I mean, it's Karen. She's pretty and professional. Like, what?
And it's like, bro, like, I don't know how much of last night they needed to see, but she was very clear about her caring about her image. And let's make something very clear about that, okay? If she cares more about her, quote, image, and I mean in every sense of that word, okay? Like, not just the way she physically looks, but what people think of her. She cared more about what Channel 4 was going to look like in her pajamas than she did that she had been indicted on murder too.
And we don't want them to think that we're justice for John O'Keefe. We need to draw that distinction.
That really burned me. I'm like, did she just say, and that was another one.
But I'm like, thank you for saying that. But the problem is her cult will still just pretend like she doesn't ever say that. Like,
I know.
because it pisses me off that they fucking use his name to raise money for her and claim that they want justice for him. So I'm glad she said that, because anybody with a brain that actually gives a shit about the truth now knows the truth.
Oh yeah, and not only that, but like she said something along the lines of like, I wanted to distinguish ourselves from justice for
Yeah,
John and
that's what I'm talking about.
prosecution.
That
So
thing-
I told them pink. I've never worn it, but I like it. So essentially, you tried to ruin my favorite color. Everybody on planet Earth knows like pink's my favorite color, including like my knife block at home is pink, my toaster is pink, my pots and pans are pink, my curtains are pink. Like my plug, like the things that go over your like light switches and plugs, those are all bedazzled pink. Okay, everyone in my house. All right, so like I kid you not when I say like pink is my favorite color. All right, she tried to ruin pink for me, and she doesn't even fucking like it. It's not her favorite color. She just wanted something bright.
I also think it played into her whole misogyny.
It did.
I think that was,
she's very clear about the fact that she's controlling, and that plays out in numerous aspects. It plays out in the courtroom when she's literally trying to be her own attorney. She's got the computer and she's doing this and she's doing that. It plays out all over the place where she has to know every tiny little thing about every YouTuber that ever says anything about her. Like, I kid you not. Like, I literally went through this with her trying to control what I was saying on my own YouTube show. So it's like, you're talking about someone that has to have control over every tiny little aspect. What would make you think that she would just leave John there? She got in a fight with him because of Bella's mom, right? Bella's mom was the problem, right? So that's a problem. You're going to argue and fight about that, but she just left him there, right? No, you lose control that way. You don't have the control. She's not just going to let him go and go home.
Yeah.
That's not how it works with a control freak. It just isn't. Like, anybody who's ever been with an abuser or a narcissist knows that firsthand. Also, anybody who's ever been with an abuser or a narcissist should see right through the sewer turtle in about 10 seconds flat. Yet some of them claim that they're, victims. I like to call myself a survivor of domestic violence, but they can't see through it. It's sitting right in front of you every time you turn your screen on and watch him.
Yeah, both of them though. That's what I'm saying. Like, most of her support is from people that have suffered at the hands of abusers and narcissists and shit. Yet they don't see it in either of them. Like, these are two of the biggest psychopathic narcissists to ever walk the earth.
Literally. Like, I literally kid you not when I say like the sewer turtle's brain needs to be studied one day to see how he became such a damaged, demented human being. Because I've never seen someone lie the way he does and blame other people for something he is currently doing at that moment, knowing that the other person didn't, knowing that he did, and doing it with a straight face and lying to thousands of people, knowing that eventually that lie is going to be pulled back in his own trial. And what is he going to say then? It's still just, now let's remember, long before the Karen Reed case, okay? Every other scandal he's been involved in, I just want to point out that every single one he has claimed was a setup, okay?
Yeah.
And lo and behold, we find out in all of those instances, he was setting other people up. He was lying the entire time. So what would make people think this would be any different? It's not. It's the same playbook he's been playing for years before this case even arrived. Go back and once again, do some research.
But that's what I mean. I think these people, how I've been in an abusive relationship, you've been in an abusive relationship. So like we know how to identify it, but these people at the same time, like when I was in it, I even knew I was in it, but it was like, it's comfortable. That's why I stay, because I'm used to it, because it's my normal. And if I was being treated well, that would be uncomfortable. So I'm staying where it's comfortable. And I even recognize that in my own sickness. These people are the same way. Like the way that Turtle and Melanie Little and these people, I mean, Melanie is just as bad as Turtle, but she does it with a little bit more class, but she degrades her audience all the time too. And it's like, they like this.
Without your audience, where are you? Where are you without your audience? Like, I just don't, in my brain, it doesn't fathom how you cannot appreciate the people who are cheering you on and supporting you. I just don't get it. It does not make logical sense to me. How could you be okay with lying to them? Like, maybe they're just seen as numbers for these people, but for me, every single number, this number at the top of my screen, this 870 number, that's how many people are watching. You could say half of those people are hate watching. I still don't give a fuck, okay? Like, 870 people, and each one of those people are the reason why I'm here, okay? I appreciate every single one of those numbers as actual real life people. Some of these people in this number right here, this 872 now, some of these people I've gotten to know and are like family to me now, okay? So I just don't get how you can act like those people don't matter and just so easily lie, degrade, smear if they don't agree with you, like make shit up because you're trying to hide your own shit. Like, I just don't understand it.
Because it's the same thing as us not understanding how Karen Reed and Turtleboy can function the way they do. They're the Melanie Littles and the Brandy Churchwells and the Glares and all these people, like, they're not in this to be good people. They're not in this to be spreading awareness and trying to help anybody. They're in it for themselves. Therefore, they don't give a shit about their viewers from the time that they turn on that computer every day, and they go into it knowing that.
They do, because I mean, I think it was, wasn't it Churchwell that admitted that, like, oh, well, they pay my bills, so like I have to say it. Like,
yeah,
no, you don't. That's the thing. You have a choice, right? You have a effing choice. I had a choice. I had a choice. I knew the hit I was going to take when I realized that she was not innocent. I knew, okay? I knew I was going to lose hundreds of dollars a week. Hundreds, okay? And I knew that. But what's more important, the money in the short term or your integrity in the long term?
Well, like
My
I
word
said,
is all I got. I'm a poor person.
These people built their channel knowing that they, like, Melanie Little's channel's been built off of, she claims to be a victims' rights advocate, which also disgusts me. But yet she's on here all day, every day, bashing victims and holding up murderers. Like, but see, that's what I'm saying. Like, there's a large contingency of her audience that loves that about her. They like that sickness in here, which is why we attract the people that we are. We are who we hang out with, kind of thing. So they like that. They like being lied to. They like being mistreated. They like being taken advantage of. But then the other part of that is the part that pisses me off is there's a lot of people that, like, I'm constantly calling out Melanie, and I'll get people like, she's such a good person. Da, 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 I love her. And it's like, no, I'm doing this for you. You clearly, like, I get it. You're going to tell me I'm stupid because you're brainwashed and you believe her when she tells you that she loves you. She's laughing all the way to the bank every time she goes on vacation with all the money that you guys are funneling into her bank account. She does not give two shits about you.
Well, that's the thing. People don't seem to, people are like, oh, Emily D. Baker. I'm like, you realize that she stopped being an attorney. She no longer practices law to be a full-time YouTuber, right? Just FYI for people who don't know that already. She is not an attorney anymore. She stopped being an attorney because she told an article that she makes more money on YouTube than she ever did being an attorney.
Yeah. Spreading
over $100 grand or $200 grand a year, I guess. Like, which is like all well and good. I'm for people, like, striving to do better and be better. And like, hey, like, if that's what you want to do, you want to be a YouTuber and you want to make that kind of money, like, all the more power to you, but do it with a little bit of goddamn integrity. Don't do it to just say whatever's popular because that gives you the most views and it gives you the most subscribers and it gives you the most do it with some integrity. I started my channel for a reason. I started my channel for actually two reasons. One is my friend Miguel, who went missing in the early 2000s, who has still never been found to this day. He was my roommate and friend. And one, because my friend's mother, who went missing and still has never been found right before the pandemic. So we're talking years and there's no sign of them. And I said to myself, if I can do their cases, if I can do current, old, like all sorts of cases, maybe some new information will get, pulled up. Maybe not just in their cases, but in any case, I can help, right? Like, in any way, like whether it's giving support to the victims. I've been a volunteer advocate for 18 years. I worked in corrections. I know the law. Like, I worked in a prison for the criminally insane. So it's literally mental health and corrections. Like, I have PTSD, CPTSD myself. I'm a survivor of domestic violence. I am a survivor of addiction. So over 18 years from opiates. Like, I have a child that has a terminal illness, like, and a disabled sister and sister-in-law. Like, I have a lot to offer helping people. I've been doing it for 18 years. And I just wanted to do it in a way where I could help more people at once, if that makes sense. Like, and when I took on this case, to answer sort of Maestro's question, like, I never thought like it would be where it is now. I never thought in a million years I'd have to deal with the things that I've had to deal with when it comes to this case. And I think the first time I ever encountered Aiden was, oh God, maybe an event for the case. I think it might have been an event, or maybe court. I can't remember. I attended some court hearings outside and streamed the outside. It might have been one of those times, but I think that was one of the first times I encountered him, honestly. And then other people would reach out to me and say, you know, like, oh, hey, we love your show. Like, do you think like you guys could stream together? And like, I wasn't really like, yeah, I was just kind of like, I'm doing my own thing. But if like, you know, whatever, there's an open invitation, always has been on my own channel for this kind of thing. So like, you know, if people want to come on, like, they're always welcome. I have no problem with that. Some creators have a problem with inviting other people on because they think either that person has nothing to offer because they don't have enough subscribers they can bring to them, or that person, they don't want their kind of subscribers. So people like limit who they'll bring on. I don't care if you have 0 subscribers or 5 subscribers. Like, I think everyone starts little, and if I can give anybody a boost, I'm going to do it. Like, we should be lifting each other up, not knocking each other down. And I have a serious problem with people knocking each other down constantly, because if that's what you're doing consistently and constantly, that means there's something wrong inside you. If you feel the need to constantly attack other people, it's not the other people you're attacking that is the problem. It's you. Like, you are unhappy with yourself, you're insecure about yourself, therefore you think it's okay to do these things to other people. I have overcome a lot of obstacles in my life, a lot. I have spun my life in a 360. I never asked to be in foster care and abused. I never asked to be domestic violence abused. I never asked to be abused as a child or sexually assaulted as a kid. I never asked for any of it. And I went through hell from that point until I was a young adult. And then I got my shit together. So I've been through quite a bit in life, but I also think that every tiny little thing that I have been through has brought me to this point where I am able to give a little insight to people. I'm able to give a little empathy, a little sympathy, a little this, a little of that, right? And I'm able to at least steer people in the correct direction of where they can get the correct help for whatever it is that they need help with.
Exactly.
Nobody knows Aiden from before Karen Reed, meaning he loses his entire audience on the regular. Yeah, he does. That's the funny part, is I actually didn't really know. I knew the name, but I really didn't know much of anything about who he was, the things he had done to people previously, until I had to deal with it myself, because I accidentally found out about his numerous girlfriends and him, you know, cheating on his wife, and he did not like that I knew that. So like, I become public enemy number 1 after I knew that. And that's how that went. So, I mean, it is what it is. He can call me every name in the book that he wants. It doesn't change who I am. The people who know me know who I am. They know what kind of person I am. They know I'm a reliable and good friend, person, mother, sister, like, and so I don't need his approval or his audience's approval.
Exactly.
And I think people need to realize that, like, if I can deal with the level of harassment that I have dealt with from him and those people since the winter of 2023 ongoing till this day, then anybody can get through it. Anyone. And it's not right what he does to people, but you're not alone. You're not by yourself. And there are plenty of people who can't wait for some justice and for his ass to be sitting in a jail cell where he ultimately belongs for the rest of his miserable life. Along with Karen. Both of them. They can wear pink if they want. In a jail cell. Accidentally, kind of, Suzanne. I was like, I just told people, I don't know if you were here for that, but I got involved in YouTube and doing these cases because of people I know who went missing. And I love the law, and I figured I had something to give to the audience, you know? And I think I have, and I continue to. And I'm glad to be here, but it's been a wild freaking ride. I'll tell you that. Picking this case as one of the first bigger cases I dealt with, because I've done a lot of the smaller ones. I've done Sandra Birchmore twice, and I'll continue to cover hers as long as things develop, because I think Sandra and her family deserve justice. Her and her baby and her family deserve justice, and I've covered hers twice, and I've covered other cases, but this was kind of one of the first ones that were like a consistent, constant one. And it was just something in my area, something interesting. And I was like, you know, it had to do with, John was a cop. It was in front of a cop's house. The girlfriend, backed into him, or so-called backed into him. She might be innocent. She might not be. And it was, again, in my area, something that I could go to a courthouse, get the documents, and follow. I wanted to start in my area because your YouTube channel is going to grow word of mouth, right? So if you have a lot of people in your area who know about you, maybe talk to other people who are like, oh, hey, remember so-and-so that you knew 10 years ago from high school or whatever? Like, oh, they have a YouTube channel. So like, I wanted to do something in my area. I just really had no idea what I was getting into. I'll tell you that much. I don't think anybody could have predicted what this case has done to so many people.
Never.
I don't think that's the thing. I honestly don't think the Aruba trip is really that important. The one thing it shows is Karen has a tendency to be explosive and jump to conclusions and believe in her head crazy things that didn't happen. You saw him hugging someone he's known for fucking however long, 20 years, 10 years, 15, doesn't matter. And you magically thought they were kissing. And in your head, you had to keep bringing that up as if it's really something he did when it isn't. He gave her a hug, God forbid. That's kind of what it shows. Other than that, I think you wasted probably a couple hours on the whole Aruba thing. I don't think it ultimately proves her guilt or innocence. I think focusing more on what she did that night at Fairview and how it got to that point from the beginning of the night until the end of the night is more important than really the Aruba stuff.
Yeah, and I feel like the kids' testimony is going to bring in all of that relevant information.
Exactly. They have the kids to be able to say, like, the relationship was rocky. It was on its last legs and it was pretty much almost over. And then you have also her and John's text from that day and the day before.
Yeah.
So I think that's relevant enough to not have to do the Aruba stuff. I think the Aruba stuff was kind of just, you're wasting time in that aspect because it's not really like,
it's not going to make or break the
it's not
evidence.
going to make or break the case. It's not really something that needs to be told, I don't think. I think it's more of, thank you, Otter, more of a distraction, really. Like, it's just more things that you don't want the jury to have to remember so many details that they're overwhelmed. You want them to get the basics down, and you want to keep nailing those basics in over and over and over and over until it's a timeline in their heads and they can picture it. That's what you want.
Yep.
Yes, I am, Suzanne, in this area. I am in Massachusetts. I wouldn't say I'm near him. I don't live near him. He lives in Western Mass. I do not live in Western Mass, but I am in Massachusetts, very close by to where the courts are. I think Hank knows he can prove murder too. People keep saying to me, like, I don't think he's gonna be able to prove it. And I think he absolutely will prove murder too.
Absolutely.
Hey, Jack.
I've known it since the first day I saw him in court. Even I could tell he was still kind of finding his feet, but I was like, this guy is going to bring it up.
I was trying to tell people, I was like, if you guys remember back then, I was like, pay attention to Hank. He is extremely intelligent and he commands a presence when he is in the courtroom. Like, just watch him. And he's just absolutely brilliant. He doesn't miss a beat. He has every attention to detail that you want from a Commonwealth attorney. And like, unlike Lally is very monotone, I can think Christina Rex said it, like very not flashy. And Hank isn't flashy, but he commands you listen and pay attention to the words that are coming out of his mouth. So where you find yourself drifting off when Alessi's talking, because he's talking in circles and he's saying the same thing over and over and over, just in different words. When Hank talks, you can't help but to literally listen to every word he's saying. That's just how he presents, And he also knows that, like, when it comes to this case, They're going to try every dirty trick in the book, so you better be prepared. And I promise you, Hank is one of those people who is always prepared. Always. So, I think Hank is going to be very intricate in making sure that, like, Karen sees justice in the inside of a jail cell. He absolutely does know that he needs to what is needed to bring it home. He does. And that's what I love about Hank is he knows what he's doing. He's not a rookie at this. Like, not even a little. I'm getting texts about you, Sonny. They say they love you.
Thank you.
I mean, there are so many things we could possibly go over, especially when it came to that God help me here, documentary last night, and there's multiple parts of that. So there's going to be a multitude of parts to that documentary.
Yeah, tonight there's 2 more, and then Wednesday, the last one, right?
I thought it was 5 parts. We can say it's 3, but I think it's 5. As far
No,
as I
it
know,
is 5 because last night was 2, tonight's 2, and then Wednesday's 1.
Right, exactly. So I'm like, yeah, 5 parts. It's going to be interesting to see where ID brings the rest of it, because that first one, like, she does not look good. She looks like the whack job that she is, only caring about herself, very self-deluded, and everything is about Karen and the Karen show. If you heard Jackson when they were doing openings, they were practicing openings, and he said to Yannetti, I don't want anyone, me, you, or Liza, saying,
Yep.
what was the word he used that Yannetti used? Tend.
Yep.
He wanted to say that the evidence tended to show,
Yep.
and Jack didn't want anybody using the word tend. Well, I wouldn't use it either. It's like lawyering 101. You don't want to, like, suggest that the evidence shows your client's innocence. You want to say that it does. You know what I'm saying? So I'm like, Yannetti's supposed to be a seasoned attorney. I mean, you would think that he would know that it's not a word you would want to use.
Yeah, I mean, literally by the time Yannetti finished that sentence, I was like, what? Like, you can't use that word. And then Jackson right away says that. I'm like, yeah, I mean, I knew that. Come on.
Like, what in the actual hell? Like, y'all, Sunny has her own channel. So you guys have to, like, go over to YouTube and follow her on her channel. It's called Sunny Spirit. So, you gotta.
Yeah,
you gotta go there.
I have lots of content. All it is Karen Reed. I started this because I don't live there, and I wanted to cry and hug the O'Keefes and the Alberts and the Proctors and the McCabe's, and I'm like, I want to reach out to them. I want to help them, but I don't want to harass them. And I'm like, I don't know what else to do. I was jumping out of my skin, so that was the only thing I could do is speak on it. So just
I will tell you this. They
for
see you guys. They see you guys. They appreciate you guys. Like, they watch. There's 910 people watching this show right now. You can bet that some of them are watching. I know this for a fact. And they appreciate the support. They do, because for so long it was just constant harassment to them.
Yeah, I
from
mean,
these
it just
people.
horrified me. If it wasn't for what Karen and her, and ultimately her defense team, like, that's why I was just perturbed today, and I'm still pissed because I'm never gonna not be pissed, because these lawyers should not only lose their licenses, they should go to prison for what they have done. Like,
I agree with that.
Along with Levy, like, they have perverted justice.
Levy needs to be held accountable for what he did. 100% needs to be held accountable. And I don't care if I have to scream from the rooftops until the day I die, but I will make noise because he needs to be held accountable for that. Like, I'm sorry, but there is no ifs, ands, or buts about. There's no sweeping that under the rug. What he did was wrong. It was wrong.
It was deplorable.
It was disgusting. And the newest view, the new lady there, what's her name? Leah Foley? Yeah, Leah Foley? Yeah, Leah Foley. She was not happy about what he did. Hence why she did what she did as soon as she took that office.
So they all have to be aware, right? Like if he's like the head honcho, everybody under him knows what he was up to.
Yep.
So yeah, I mean, there's still a little bit of trepidation, like, because I just feel like, I mean, well, because, okay, see, I'm not a social media person, but I think it was after the first trial. It was probably like a month or two ago. It was the first time I even went on X because I'm like, I got to find out like more information. And I keep hearing other YouTube creators talking about stuff that's over on X. And I'm like, I don't want to be on this shit, but I have to just go snoop. But then I got kind of like, I had to post because I wanted to keep track of the stuff. So I'd repost other people's stuff so I could find it again, kind of thing. So I couldn't.
I like on X at least. I'll bookmark it so I can save it. I'll just hit the bookmark button because then you can go look in all your bookmarks on X and you can see all the things that are important that you want to remember. I also still very much do handwritten notes. I still write handwritten. I have notebooks and notebooks and notebooks full of handwritten notes. I have an entire notebook just from the last trial.
Yeah, I'm a big writer too. We're the same generation, I think. So I feel like you and I are very much the same kind of creature. My puppy's giving me kisses.
Oh, puppy. So cute.
She knows when I'm like, when I start talking about this kush.
Well, for me, it makes me even angrier they didn't put him in jail because, like, it makes me immediately think of like all of his victims, and that includes Lindsay. Like the hell that she has been through, the absolute hell, the hell. Like he deserves to sit in prison for the rest of his miserable life for that.
Both of them, they both
leave her alone.
deserve to sit in the hole, not just prison, but they need to be isolated so they get no more attention from anybody ever, because that will be the worst punishment for these narcissists.
No, the worst punishment for him is never being able to actually go online anymore. So he will not be so happy in jail. He likes to pretend like everybody just like was hunky dory with him being in prison. I will tell you firsthand, I have friends who work there, and I also have friends who are incarcerated there, and they both tell me the exact same thing. That is BS, dude. Absolute and utter BS. He begged to stay in that cell in medical.
Oh, yeah.
Was over. He was afraid, very afraid, and as he should have been. There were threats against valid threats against him from inside the prison from other inmates.
Yeah.
So, I mean, the jail did keep him alone, which they should have done anyway. But
that's the other thing that concerns me about Canoni now is like this bitch, when she gets convicted, she should. I mean, that's gonna sound egregious, but I wish that she could get the death penalty on this case. But anyway,
that's the thing. Massachusetts don't have the death penalty, but if you get federally charged in Massachusetts, so for instance, William Cornwell and Rebecca Moore's there, he was federally charged, so he very well could get the death penalty in the state of Massachusetts.
Oh yeah, for sure.
Because he was federally charged, state charged. So you can get the death penalty on the federal.
But I'm concerned, like, there's no way in hell when Karen gets convicted, she should get the most severe punishment. But based off of what Canoni's been doing, I'm just like, is she going to? Is she going to actually hold her accountable?
Yeah, you have to remember, a judge has to say, right? Once you get to sentencing, they're actually allowed to give a little bit of what they feel. You know, like I feel like you did this during trial. And so for those reasons, the mitigating and unmitigating circumstances, I'm giving you this amount of years. And I really think that there aren't a ton of, like, there's not a ton of good that would be, giving her less time. It's going to give her more. Like,
I hope so, because if after all of this, she's light on her sentence, I will come unglued.
Yeah. I don't think she will be. I don't believe that she will be light on her sentence at all. I think she'll have the book thrown at her, as I think he would have the book thrown at him as well if they are guilty. Oh, do you have us on YouTube on a different screen?
What's that?
Do you have YouTube on another screen?
Yeah, I have it on my TV and I'm talking on my phone.
Oh, well, that's why. There's feedback.
Oh, I have feedback, but I have the TV muted.
Oh, yeah, but you're probably so close to it. That's why it's giving feedback.
Okay, hold on. Let me exit out. Did that help?
Let's see. It's when I talk. Yep. It's when I talk if they were hearing the feedback. Yeah, it's gone now. Oh, no.
When I talk?
When I talk. I can hear it. The interference Elise is talking, Jack said. Yeah.
So my feedback is still on there?
Yeah, turn your phone down a little or your computer down a little. See if that helps.
Is that better?
Let's see. Is that better, you guys? I could still hear it a tiny bit, but it doesn't seem to be as bad.
Oh, I wonder if it's my fan. I have my fan. Let me shut my fan
Sounds
off.
like I'm echoing through something, whether it's speakers or something.
Ouch.
Maestro said check and make sure your speakers aren't on. Is that better? Yeah, you guys said it was a little bit better.
I don't have I don't have any kind of setup. I just literally use my cell phone, and then when I watch
So it's
YouTube.
probably just because of service or whatever it is what it is. I can't really hear it anymore anyway. It's almost pretty much gone. So must have been
Okay.
partly because YouTube was on and partly because of maybe service. I don't know. StreamYard's funny on the phone. It drives me absolutely insane. I got an update on my computer yesterday for Windows 11, which should have came in like December on my computer. I don't know why it's coming just now. And it like messed with my microphone. So like now every time I go and I do a live stream, I have to like mess with all these different settings to like unmute the mic when it should automatically be unmuted. It's like, and not on StreamYard, but like actually in the computer. It's weird.
Yeah. See, I don't have good volume. If I I need to get like a mic or something so that I can use my computer, because if I try to talk on my computer or even hear YouTube on my computer.
I don't have a regular mic either. I need to get one desperately. Just can't
Yeah.
afford it with everything with the hospital and stuff. But I got these Beats headphones for Christmas like 2 years ago. And they're like the sport Beats. That's why they have like, the cord on them. But the microphone on it is on both sides. So when you have it around your neck like that, there's a microphone on this side and there's a microphone on this side. And I absolutely love these headphones. These headphones are, and when you're not using them, look what they do. When you take them, like put them down off your neck, they actually magnetize together so that they don't fall off and you don't lose them. See?
Nice.
I love them.
Very nice.
I have used OBS before. I have. That's what I started with a very long time ago when I was going to make like long form non-live videos. I obviously, as you guys know, mostly do live videos now and not content that's not live. But I have used it a few times before for trying to figure out how it works, editing. I use different editing software now for other things, but I would love to pick your brain later about that freak though, because like I've heard that one's a little bit better when it comes to other options on it for like sound and picture. And I also need to get a cam too. I'm just using my regular, computer, my laptop camera, but I definitely need a better high resolution camera.
Yeah.
Anybody else got any questions while we're here? Because it's 2:19 and I am starving like a hostage, but I will answer anybody's questions before we head out for the day. I guess there's no court tomorrow. There's court Thursday now instead. So remember, nothing tomorrow. There was supposed to be, but there isn't going to be. But we will have it on Thursday. So.
And what are they doing more limine motions on Thursday?
Yep. They still have all the Commonwealth, most of the Commonwealth and limine motions to do. And then she wants the defense witness list. She wants quite a bit of different things to be done by the end of Thursday. So I don't think the trial will get delayed due to that appeal, because I don't think that appeal is winnable. And I think any judge with any common sense would know that that appeal is not winnable. The Commonwealth is opposed to moving the trial anyway. I just don't think that they're gonna, the judge, and I believe didn't sanction Jackson
because of that. Yeah.
Yep, because of that. So I highly doubt she would move it now.
Yeah.
So I know that's my like famous line when I'm starving like a hostage. Yep, starving like a hostage.
So is Thursday at 9 a.m. again?
Yeah, 9 a.m. Yep, it's 9 a.m. I don't have any information on the paint test. I'm assuming what they're doing is testing the paint that chipped off onto the car. I don't know. I have to look into that one. That was one of the things that I did not have a chance to go and look into.
Maestro said he had something on his ex account.
About the paint?
Yeah.
Oh, good. Maybe you can check that out, Barb, over on Maestro's account on X. That's one of the things I did not have a chance to like look into. I try my best, you guys, but you know, I was on the phone with my daughter's doctors for over 2 hours, I think, yesterday after being with you guys. So, and then my little one, you know, comes home from school and it's homework and bath and dinner and you know all that. So, and between that and going back and forth to the hospital, I haven't had a chance yet to look at some things, but I'm going to try today because I'll be home today. And I'm going to try to look at some things there. I was absolutely disgusted by the blatant lie Jackson made about the sewer turtle connection, because literally he damn well knows that he told Karen, which she admitted in the documentary yesterday, how to go through a third party to talk with him and how to give him all the public information. And let's be clear here. She also gave him non-public information. Okay, so she said in the documentary, like, they said I could give it to him as long as it was public. She also gave him non-public information. So that's bullshit. As
Yeah,
we
like
all
grand
know,
jury testimony and autopsy photos and
not public.
and like it's been said in open court and in court documents that Jackson and Unetti had like 30 calls with Aiden himself. Like
Themselves, right.
How can Judge Cannoni not call that out? Like, hello, we have demonstrable evidence here that you clearly were involved in this. Why would you be calling him? Like,
yep. So that's the thing. What they're going to say is we're allowed to do a PR campaign about the case, but they're going to argue they never said it was okay to harass anyone. That's where because it's fully legal for them to do a PR campaign, but they don't agree with the harassment. Let's get real here. If they didn't agree with the harassment, they would have stopped any contact with him a very long time ago. Have they ever told him to stop? Has Karen ever told him to publicly stop? Has she ever told him to stop going after people? No. Did they cut ties with him because of his behavior? No.
But what they're not allowed to do is feed Aiden information to have him report on it and then take that into court and pretend like they don't know Aiden, but use him as a source of media where the information that they leaked him is then used in court as evidence that it came from the media, which it came from them to bring to him. And then to take it even more egregiously, to have Josh Levy call in these witnesses who have been intimidated and harassed and terrorized for years by this psychopath and her fucking cult following, and use Turtleboy's freaking information from his blog, which they know damn well that's where the campaign is coming from, to then to the U.S. attorney question them at a grand jury proceeding with that information.
That's why I honestly think a RICO case should be brought on all of them, because
That's
at this
what I'm
point you have the
saying.
racketeering, especially with the sewer turtle, like the amount of blackmail / extortion, because the law here the blackmail kind of goes with extortion for the law en masse, but like the amount of blackmail, extortion, dog whistle threats, like those kinds of things that Aiden has just in his phone alone is absurd. They could get them on RICO. And usually the feds love using RICO. So why not use it in a case that it actually freaking applies to at this point?
Yeah, and you can't tell me that all this money that they're funneling in, that's all getting to these YouTube and social media people.
Because who else is being paid with it? The attorneys all say they're pro bono now. None of them are getting paid. So where is the money going?
Oh, they're going to all these experts. That's what they all say. I'm sorry. You know, Karen gets $5,000 at a time, just
at a
like
time on
Venmo.
Right. Per day, up to 5,000 per day, and sometimes they'll send 5,000 and another 5,000. So it's like, bro, no, it's not just paying for the experts. There's far more money being exchanged than just experts. Let's get real.
They're laundering money. And you know what I think that Hank should bring this up. The most evident thing of this crime family, they're operating like a crime family, an actual mob, and the biggest proof of that is when when Aiden did go to jail, and then he had LTL Brian
Yeah.
and the Blair take over for him and had illegal conversations with somebody that his attorney illegally told that they were part of
Or-
the
or
law
attorney,
team,
yeah.
and it was
Yep.
actually one of his turtle riders feeding out information. I'm like, this is exactly how a crime family operates. One of them goes to prison and the other one takes over until they get out of prison. This is exactly what this is. It is RICO all the way.
Bradel already is on record of having lied while he was a prosecutor in a case where someone spent 30 years in jail.
I
It
think I
doesn't really
saw
work
that.
when you take him as a client, knowing that not only does Aiden lies to his own attorney, let's be clear here. He lies to all his attorneys. He does not tell them the truth about everything. So stuff like happens, and then they're like, "Oh, Aiden, why the fuck didn't you tell me?" Right? Because he lies to them too. But make no mistake, Bradel knows a lot about a lot. And a lot of things he will sit there and lie to the court about willingly and knowingly. Okay. So make no mistake about it. He's got a history of doing it. He isn't just going to magically stop doing it, nor has he. He's been caught in numerous lies to the court. So it's like, bro, we know of at least a dozen that we can prove. And then there's the dozens and dozens and dozens that we can't actually prove, but know already are bold-faced lies to the court. Come on. I remember that. I remember in Delphi, they stopped everything to figure out where that leaked from and how it got leaked. And then people
for that. for as much as Gull took, I didn't get into the Delphi thing because I can't do kids stuff. I can't.
Yeah, it's hard. I know it's hard for me too with kids.
So when I started hearing about this, and I was like, what is this? This judge is this is blatant corruption. But then once I did pay attention to the reporting during the trial and stuff, and I'm like, okay, I totally get this. These were two young girls, and she was protecting the sanctity of their lives, and I can totally understand why she was being such a crazy bitch about it, but what I would give to have Judge Gull right now taking over Karen's case.
I know.
And I'm all
Some of
about
these
transparency
judges,
and stuff, but I think in that case they had a huge exception in the age of the actual victims where they could get away with as a person that loves transparency in the law, I'm totally okay with not having that be totally transparent just for their families to be able to
right.
be,
Well, I think there should be some privacy when it comes to that kind of stuff. I mean, that should really be left up to what the family wants and doesn't want for that,
Yeah.
It's just, it's sad.
I just can't believe that there would be many judges that would let this shit that she's let happen in court get away with it.
That's
And that's
far too much fly, in my opinion. Far
I
too
mean,
much.
how does she expect to ever have respect in her courtroom? I don't get it.
I don't know how she could at this point. I don't know how she could possibly expect that she would ever. You just invited every attorney from here to Kalamazoo to do whatever they want in your courtroom, and you're not going to do a goddamn fucking thing about it.
That's what I was gonna say earlier. I got sidetracked, but I feel like she actually treated Lally more disrespectfully than any of these defense attorneys who have blatantly disrespected her to her face. I mean, I felt really bad for him. I feel like she was just really shitting on him when she should have been shitting on the defense.
And I don't understand it either, because like I said at the time, it's like these people give me, oh, Judge Kanani, then on it. She's blah, blah. Do you know how many gifts she has given the defense that no other judge would have given? So for them to claim she's biased for the prosecution, I just have to chuckle and laugh, because it's like, bro, that can be disproved in 10 seconds. Literally, I've seen people say things that can't actually even legally happen. Who do we call to get the judge removed? Good luck with that. Good luck. There's been about a dozen, maybe a dozen judges that have ever been removed in Massachusetts. So good luck with that.
Trust me, I think that there are a lot of people that actually believe Karen's guilty, that know Karen is guilty. I mean, let's be honest, this is factual. I have no problem calling that bitch a murderer. And that's my opinion, not Twisted Tragedy's opinion. So if anybody wants to sue me, you can sue me, because that's my words. But I have no problem, just like I have no problem saying you can't Casey Anthony's a murderer and OJ Simpson's a murderer, I will always say that Karen Reed is a murderer no matter what happens. She murdered John O'Keefe. It's been proven. And
Yeah, I agree. Just saying, I've said it a million times. You can't sue for someone's opinion. That's not how it works.
yeah,
can
but I'm not even saying allegedly. If she wants to come after me for that,
I
that's
didn't say
fine.
allegedly either. I didn't say allegedly. That's what I believe to be the truth. There is no you killed John. Period.
Yeah.
Like,
Yeah,
sorry.
it's pretty
Like,
fucking obvious.
sorry, not sorry.
But I think there are a lot of us that know that she's guilty that would just assume the only reason that I didn't want Canoni to be removed before the retrial was because she knows all of the stuff that's been going on. Like but I feel like that's not helping the situation. Yeah, she knows, but she's not
what is she
doing
doing
anything
about it?
Yeah,
Right.
exactly. So like there's no point anymore. A new judge that has some kind of competency and self-fucking respect would handle her shit, would handle their courtroom better, and could catch up easily enough to be like, oh hell no, this shit's not flying in my courtroom.
As a matter of
Like,
fact,
there's a new sheriff in town.
there is. I just want to play that back real quick. What she said to Jackson in the beginning of the hearing, because
oh god, but she didn't follow through.
No.
But
I don't remember if she said that she was still going to decide on sanctions, though. I think she reserved, like, still, not that it's going to be anything more than like a good talking to, or maybe a fine, or I don't know. But
is she not even going to report them to the bar?
I don't know. That could be
I would
part of
think
the
that would be the
sanctions.
least thing that she would do at the end of the trial.
I think it should be the very least thing that she should do is report them to the fucking bar. Like, come on, man. Like, all right, is this it? Yeah, okay. Let me see. I'm gonna go back to the very beginning of this one, and yeah, Karen calls people murderers all the time, dude. They say things like they're fact all the time about all sorts of us, and it's like, bro, facts are not things that are untrue that you just repeat over and over until they magically become truth in your mind. That's not how that works. All right, let's see. Scroll. Fan. What's happening? Why am I not hearing anything? Unmute, mute. Oh, they just didn't turn the sound on, I guess, yet? No. Weird. I'm guessing it's because they didn't turn the sound on this yet. Because everybody's still, like, getting ready. I just want to point out, do you guys see this right here? He sits on the very end with his computer open, never types a single thing, ever. Doesn't type anything, doesn't take any notes, doesn't nada. Just sits on
He
the
just wants to be on TV.
Everyone else, hoping that the camera, he does that so the camera can see him. He wants to be in view of the camera. He doesn't actually ever type notes or look at any. Look, they stop and talk to each other, laugh and giggle. Like, oopsie, whoopsie. This is such a bad look. Like, right here. This right here is a terrible.
But they don't care. Nobody cares. They don't care. And there are people that support them don't care. Like, it's just so disgusting.
It is disgusting. Like, dude, stop it. Like, there it is.
Yeah, I know. Where are you going?
If you go on the side, that'll be better, please.
Like over there, is that okay?
Thank you.
That's okay. How about down here on the end?
Welcome to Zoom for Government. Enter your meeting ID.
Zoom for government.
your participant, please enter the meeting passcode. You have joined the meeting as an attendee and will be muted throughout the meeting.
Cool.
The host would like you to enter. You are unmuted. You are muted.
Oh,
It is
shut up,
mental.
lady.
Legit mental. While we're waiting, if anybody wants to make sure that you give it a like and a subscribe if you haven't already subscribed to the channel, I would appreciate it. If you can donate, we always appreciate it over here. We are a small channel. We run on donations from our amazing viewers. I read them. I don't read the names if it's not your name that's on here, because I don't want anybody having your government names.
Is this the red one?
But you can do it Venmo or Cash App or PayPal. All the information is right at the bottom of the screen right here. If you catch on replay, I read them on the next stream. So if you send a donation while I'm no longer live, I read it on the next one because we want to make sure that we thank everyone. I don't know. Did she even say good morning? That's a good point, Maestro. She usually says good morning to everyone. Oh, the court officer told him that he couldn't be filming. He needed to look up, which makes no sense. So it's like, what, you wait until the judge is on? You still get the sound. No, yeah, Karen doesn't say it back, ever.
Not once.
No, yeah, I don't think she has ever once. She rolls her eyes like at the judge, basically. All she can do is make facial expressions. Sadly.
Yeah.
Elise, I gotta take a nap. I'm not feeling very well.
Go for it.
I'll still be listening, but thank you so much. I totally want to collab more with you, and I would love to talk even offline a little bit because I have some things that I don't want to ask
Yeah,
you.
just text me. Go get some rest. Get rid of that nasty migraine you got going on.
Yeah. Okay. Well, thank you so much. And if anybody wants to check out some sassy, fiery commentary over on my channel, I have the mouth of a sailor, but the heart of Mother Teresa. So if you're down with the sickness like that, that's what to expect over there. You will get lots of opinions, very strong, passionate opinions from me. So
it's good content, though, guys. So you should check it out too.
All right. Well, let's talk soon. Thank you so much again. I appreciate you, and I will be in touch.
All righty.
Okay.
See you
Bye-bye.
later.
Bye-bye.
All right, let's see if I can speed this up a little. I don't know why this is taking so. Oh, there we go. Hold on. All right, yeah.
You have a lot to.
Want the fastest working GLP-1? Of course, like as soon as I
Roe now offers to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCA. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14. And turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So.
Okay. This is it? Well, I know that's her channel, but I think that should work. Looked it up on YouTube and then went to her channel front and copied and pasted it. My chat sometimes doesn't allow links. I have to fix that on the YouTube end. And I just always forget. I know there has to be a better way for people to be able to copy those. It did? Good. No, do it. I would love to hear it. They put that sound machine on. It's annoying. Let me know if you can, though. I would love to know what's being said. I mean, obviously, she asks Karen if she wants to keep her defense counsel, and it's like, obviously, she's going to say yes. I just don't think she should have gotten that option. Gives it, obviously, she's going to say yes, so what's the point of asking her when you really know what the answer is going to be? It's like, shouldn't have based your decision on something you know she's going to say. You know what I mean? I don't know. I can definitely hear the judge there. Come on, Your Honor. For fuck's sake. Where does she come back to the soon? Okay, now.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr.
No.
Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Yannetti is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So
No, you can't.
I'm not going to tolerate false statements, any stretching of the truth,
You did.
no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to
No sanctions.
Mr. Lessie. You didn't have a chance last time on the motion to exclude the
Nothing.
testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor.
To be clear, she's not going to exclude the testimony of Dr. Wolf because she just allowed ARCA. So there's about 0% chance she discludes any of the Commonwealth witnesses for that very reason. Because if you allow ARCA and you allow Russell, you have no basis to deny any of the Commonwealth witnesses as a judge. That's just the fact when it comes to this. Okay. So, I mean, it is what it is. But I still cannot believe. Now, look it. Now they went from shitting their pants to just semi-shitting their pants and having to figure out how to, quote, retool this defense without the stretching of the truth and the lying that she said she's not going to deal with, but then dealt with this entire. I'd like to see how she deals with it in the next on Thursday, because I know Hank will bring it up as soon as they do it, because he's going to point out that you don't sanction them and you didn't do anything, and here we are again. And I don't want that. He's going to say he doesn't want that happening during the trial, because there's no taking it back once it comes out of your mouth to the jury. They know that. So when they slip up on purpose. It's because you know you can't, the jury can't unhear it. Okay? It's that simple. The jury can't unhear something. So right. Last time the judge made her sign something saying like you couldn't for ineffective counsel. So I have a sneaking suspicion that she does that again in this case. Because at this point you want to keep your attorneys, you know they're unethical, and you want to keep them. I don't think even if you do try to appeal on ineffective counsel that it'll work because of that, because you wanted to keep them. So it's like, she can appeal until the cows come home. Doesn't mean she's going to win said appeal. You know? I believe most of them will be granted with no hearing. Because what basis would the judge have? You can't say they're biased because there's no more proof that someone's biased other than what you just saw with ARCA. And you can't say that they're not qualified because you let a non-expert Dr. Russell opine on things from reading books and saying she's seen dog bites as an ER doctor. And I think Brennan made it clear that it was like just, I think it was mostly all police dogs, I believe. Like, so there's like no basis to deny any of the Commonwealth witnesses. It just isn't going to happen. Yeah, that's not going to happen. The new YouTube guy that Karen wanted, he's not coming in. I highly doubt they allow him to testify to anything at all. Like, oh, his wife, I feel sorry for Alan Jackson's wife. I do, because this whole circus, like, I'm sorry, but maybe they're waiting for the divorce until after this trial is over. I just don't see how she would stay with him after all of that. Like, I'd be out the fucking door. See you later. Like, you know. That's very true, freak. That's very true. Super true. All right. Any other comments, questions before I go? I'm still starving like a hostage and I need to go eat something. I'll give everybody a second just to make sure. Otherwise, I'm going to go eat something because I am hungry. All right, perfect. Doesn't look like we have anything. So I answered all the rest of the ones we already had. So I guess I will see you guys Thursday, right? So we have 9, it'll be 9 a.m. again. So Thursday it is. Make sure you like, subscribe, do all that fun stuff, share the video, donate if you can. There's PayPal, Cash App, or Venmo. You can donate to the channel. We only run off donations from our viewers, and we appreciate it, as you guys all know. If you donate when you're on my replay crew, I'll read it on the next one, as I always do. I appreciate you guys. I love you guys, and I will see you on Thursday morning.